Item number 45, private, under the complainant, they have advocate, they have withdrawn. Complainant advocate, they have withdrawn. Matter has to be a hard final. There may not case relating to forcing, whether there can be 2 FIR for 1 incident. Only the detail order is there. So let the matter come for hearing in the month of October.
Withdrawn.
For private persons, for the opposite party, that complainant's advocate, they have withdrawn.
Oh.
So they were ultimately, and nobody has been engaged in this. It is for orders today. So let the matter come up for hearing after in the month of October. In the meantime, if they engage somebody, they will engage.
Okay, I'll not put anything. I'll just put it for hearing.
Yes, October.
October. Why so?
They may engage.
But October is too far.
September, I have not percent difficulty.
The whole month. Let it be some because I mean.
First week of September.
First week of
September.
September. Okay.
Or August last week. August last week, maybe.
So here, Lordship,
Why it has come for orders?
Because the private advocate for the complainant have withdrawn.
here, Lordship, the CD is with us. So let it be in the second week of August, Lordship. And let it be in orders itself, Lordship. So in the meantime, if somebody appears, then it can be fixed for hearing, Lordship.
It can be fixed for hearing. In the meantime, if they appear. So let it come for hearing in the month of August if he is insisting that. So I will say that let it come out in the first week of September.
We'll put it for orders then. I mean, let them come, then we'll fix it. I mean, I don't know whether, I mean, if they come up with some kind of filing of objection or something like that. Then again, it may be difficult.
Till unless the matter is fixed for hearing, cannot go for hearing.
Correct.
Let it come in the month.
I mean, we'll put it on the first week of September for orders. Then, like, let's see if they want to file some objection or something like that. On the prayer of Mr. B.D. Das, the learned senior counsel, let the matter be fixed in the first week of September. In order for orders. In the orders column. In the orders column.
Interim is there.
Interim is there. Interim order so passed. Interim order so passed earlier shall continue till the next day.
No, item number 47.
Yes.
There's a stay order staying the domestic violence proceeding, my lord. We have filed an application for vacating the stay orders. Today they have some difficulty, my lord. May I submit, my lord, on Thursday next, my lord, the entire matter will be taken up for hearing, my lord.
Lordship, can it be on first week of August?
No, my lord, they have operated, I mean, the expertise stay is there, my lord. Let it be on 4th, my lord. Yes, my lord.
Yes, Lordship.
4th of
4th of August.
4th of August.
Lordship.
Huh?
Lordship.
Okay, on the joint prayer made by the council appearing for respective parties, let the matter be listed on 4th of August
For final hearing,
for final disposal.
Obliged.
With the consent of the counsel of the petitioner, I beg to mention item number 53. But see, here I was supposed to submit some judgments of Honorable Supreme Court. But see, yesterday due to flood, Lordship, I could not arrange chamber. Maybe taken on with next Tuesday, Lordship.
53.
53.
On the prayer of the learned council, learned standing council, customs department, let the matter be listed. When do you want?
Tuesday.
On the bail matter, this is no.
I've taken consent from his
Let the matter be listed on. Let the matter be listed on
Tuesday on 28th.
on 28.
Lordship.
On 28. 28. Consent has been. It is submitted that the counsel for the accused applicant has consented to such prayer.
May I please, Your Lordship? I beg to mention for listing of a motion matter, my lord.
Today it will not be possible. On Monday.
It's a special bench, my lord.
So Monday you do it for special bench what? So there's so many matters are given. How I'll give a accommodate time? Let it be on Monday. Monday special bench will be there. It's not that bench will not be there. Monday you do it.
May I pray, madam? May I pray, madam? I'm appearing via VC, Lordship. I'm not well. Lordship, in I don't know what 52, 52, I'm making a prayer for exam, Lordship.
Which
I've
matter?
taken the consent. item number 52, Lordship, of the
52.
supplementary list.
Okay.
I
Okay.
have not, you have not taken any consent? For
He's
52.
saying, he's saying
No,
he's,
No, I'm making mention in 52, not 22.
I think 22.
okay. On the prayer of the learned counsel, appearing for the accused.
I'm respond number 2,
You
Lordship.
are for the respondent, appearing
Yes.
for the respondent number 2. Let the matter be listed. When do you want it?
Lordship, as per the convenience of this honorable court, Lordship.
On the first week of August?
Lordship,
Okay, 5th of August, 5th of August.
oh, pleasure.
The learned
I
counsel
think that-
submits that he has a learned counsel for the submits that he has already taken consent of the counsel appearing for the appellant.
I
Yes.
further take the leave of this honorable court to appear in item number 22.5 of EC, Lord.
Yes.
May I please, sir?
Hmm.
I beg to mention for listing, my lord, bail application.
Monday.
May it please the lordship, in item number 15, my lord, Jadumani Das, my lord, we had already circulated a slip, my lord, yesterday with the consent of the other side, my lord.
15.
15, my lord.
Hmm.
Jadumani Das, my lord, that is an, lord, a slip was submitted by my colleague, my lord, yesterday.
You are appearing for?
I am for the petitioner, my lord, in this AB day. My senior is Mr. R.P. Kakoti. He has some difficulty today, my lord.
Okay.
Can it be on after 3 weeks, my lord?
Okay, on the prayer of the council appearing for the petitioner, let the matter be listed after 3
After
weeks.
3 weeks. An entry may be continued, my lord.
The interim order so passed earlier shall continue till the next day of listing.
May I please, your lordship, I beg to mention item number 9. This matter may kindly be adjourned for a day, lordship.
On the prayer of the council appearing for the petitioner, let the matter be listed. When?
Any date, lordship.
On 6th August.
May it
Yes.
please your lordship, last occasion, your lordship,
Hmm?
last occasion,
Hmm.
your lordship had ordered a bail application to be listed this week.
Hmm.
Unfortunately, it has not may come up on Monday, your lordship.
Okay, Monday.
May I please, your lordship, I beg to mention item number 26, lordship.
Hmm.
CD and DNA report was called for and charge sheet has been filed, lordship.
Hmm.
So LCR may be called for, lordship.
Let the matter come.
Yeah, please, Lordship. So I beg to mention for listing, Lordship. So there is a second application, this one will reject earlier, Lordship, and this matter was listed on 13/7, Lordship. And this one Kejari was called for and direct to list the matter after week. Now 2 weeks passed, Lordship, till that not listed, Lordship. I checked
This
the.
bench will not be available for the
That's why,
next 2
Lordship,
weeks.
Can it be today, Lordship?
Not today, not possible.
Because petitioner behind about 82 days.
Not today, not possible. 90 days.
82 to 90 days, about 82 days today. Lordship. That's why
82
I'm
days.
preparing before you.
Okay, allowed.
Lordship, I beg to mention item number 37.
Hmm?
37,
37, yes.
CD and PM report not
Hmm?
received. CD and PM report not received.
CD not received. Sarma? It-
Submitted, lordship.
The charge sheet has already been submitted. Let the matter come. You call your senior who is there when the matter
My
comes.
my senior is out of station.
But what can be done out of station? There are four councils are there. Anybody can come and appear. CD has been submitted already. Oh, sorry, the charge sheet has been already submitted. We'll have to see what is there. Okay, next.
Your Lordship, I
Hmm?
beg to mention item number 11. So the Alliance senior is out of station today. So your Lordship made the matter.
Okay, the item number 11 adjourned on the prayer of council appearing for the for the petitioner
Last week of
and to be
August.
listed in the first week of August.
Highly obliged.
To mention it, item number 35 of today's list, lordship. Is there not?
Is there not received? Okay, CD not received, let the matter be listed on 6th August.
Interim is there.
6th August, interim order so passed earlier shall continue.
But similar prayer regarding item number 41, lordship.
41. CD not received? Okay, same order.
Interim is there.
Both on 6th. 6th August.
Alright.
Interim is there, ne?
Yes.
Interim order so passed earlier shall continue. Yes. 49. Yes.
But listing is there. so
Okay,
I
on the,
have to check.
okay, on the prayer, heard Mr. M.R. Khandakar, direct counsel appearing for the petitioner. Also heard Mr. B. Sharma, learned APP for the state. For the state. The learned counsel appearing for the petitioner submits that he has instructions to withdraw the instant petition. Instant petition due to an inadvertent error. Inadvertent error happened in filing the instant petition. The instant criminal petition is dismissed on withdrawal.
50.
Hmm.
Lordship, I may be allowed to withdraw.
You want to withdraw this? Why? Where is RNB Chaudhary?
Lordship, client has the instruction, petitioner has the instruction, Lordship.
Okay, heard Mr. N. Kalita, a learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APE for the state. Mr. N. Kalita submits that he has instructions to withdraw the instant bail application. This bail application is dismissed on withdrawal.
One, total.
Scan copy lodge, charge sheeted method.
Matter, FIR page number 16.
Heard Mr. What is your name?
ABT Hope.
ABT Hogg, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APE for the state. This is an application under so and so. Then you write, call for the PCR in connection with special NDPS case number 23 from the court of the learned additional session judge FTC Hojai. Let the matter be listed on 7th August.
Let it be on the second, third week,
Hmm?
10th or 11th.
10th August.
Your lordship may kindly call for the updated case diary because your lordship was rejected earlier on 13/7/2026.
Already rejected.
Yes, my lord, but we have placed some new materials and facts. But even then, I will request your lordship.
Okay, heard Mr. B.D. Kumar, learned senior counsel, assisted by H. Singh, J. Singh, the learned counsel appearing for the accused applicants. How many applicants? One.
One.
Accused applicant also heard Mr. B. Sharma, learned AP for the state. This is an application so and so, then I'll call for the updated CD in the instant case, updated CD in connection with Buko PS case number 143/2026. Let the matter be listed on.
As per your lordship's convenience.
Hmm?
6.
Hmm?
Fifth or sixth.
3rd of August.
Hmm?
3rd of August.
5th of August, 5th of August,
My 5th, 6th, 7, I am out, my lord. Then
4th August, 4th August.
4th August. Obliged.
Lordship, learned counsel engaged in another court, finally, learned counsel.
Oxbow matter lordship. Notice will have to go. Oxbow matter.
Notice has to probably issue notice. Okay. What is your senior's name? M.H. Ahmed? Okay, we'll put his name. Your name, R. Begum. Okay. Heard M.S. R. Begum on behalf of Mr. M.H. Ahmed, the learned counsel appearing for the accused applicants. Accused applicant also heard Mr. B. Sharma, learned APP for the state. This is an application under so and so, so and so. Then you write notice to respondent number 2, in terms of the prevailing notification issued by the Gauhati High Court. Notice to respondent number 1 is dispensed with as Mr. B. Sharma, and APP puts in his appearance. Call for the CD, let the matter be fixed on
10th of August.
10th of August.
Four.
Yes,
This anticipated application I move against the FIR is page 24. It's a very big FIR, but it is like a petition. It's a kind of weak petition.
you tell me what is the
Yes,
summary
what
of
is the
this?
summary I'm telling you. My accusation, my accusation, student class, his.
Your name is Harshit Nahta.
Nahata, yes.
Yes. And who is Manish Nahata?
Manish Nahata, his brother.
Brother has filed against you.
It is a family dispute, it is a case of family dispute.
Hmm.
That is why he has lost in this FIR. Just he is a student that he was, what is the FIR? he says that he is hacking his password and doing some mischievous things.
Hmm?
He is hacking his password and doing some mischievous things in the ICI portal. But he, that informant is a student of chartered accountant. He is a chartered student.
It's 29 Lord Ship.
Yes, I have come to 29 only.
Yes.
In summary, the first instance, firstly, my profile.
And this FR was lot after
I
it,
see
after
AI
2
was
years.
hacked and tampered with. Secondly, my details are hacked and changed as to tamper with my admit card details and attempting to bar me from appearing examination. Thirdly, the email ID was hacked and used to erase essential information. What is this, jealousy or what?
This
With
is jealous,
huh?
it's kind of jealousy.
Jealousy. So we'll call for the CD. No interim at this stage.
But my lord, in that case,
No,
my lord,
this is bad within, between the cousins, you are jealous of your cousin.
please, if you lordship go to the
Heard Mr. S. Mitra, the learned counsel. appealing
last
for the
time, last time also same thing happened, my
accused,
lord.
accused, huh?
Last time also same thing happened. They have lost
Last-
an FIR. Last occasion also,
Hmm.
he has lost an FIR informant.
Hmm.
Again, he has withdrawn because of intervention of grandfather.
Hmm.
I have annexed this 37,
No,
38.
but you are doing the same thing once it has done.
Same cause of action. Same cause of action.
Okay, we'll see what is there in the CD. Heard Mr. S. Mitra, the learned counsel, appearing for the accused applicant. Also heard B. Sharma, learned APE for the state. This is an
Because-
application under section 482 of BNSS 2023 for granting anticipatory bail to the accused applicant in connection with Silchar PS case number 306/2026 under registered under section
Also
316/3/3 of the BNS Red with section 66/66C/66D of the Information Technology Act. Which is available sections? Which are available sections? Which are non-available?
Which are not, I'm telling you, my lord.
Hmm.
Just a minute. Page,
Which are those?
page 10, Maya. Because of page 10.
Base 10.
Page 10. 316 page 10. 316 318(4) is non-available section and 336(3) is a non-available section. Cheating, for the purpose of cheating, and there's electronic.
Okay, the allegations made in the FIR dated 4/4/2026 by the informant that the accused applicant after hacking his after hacking his profile. Your profile where? Hacking what?
ICI.
Hmm?
Intel Council of
No, hack, but he hacked this ICA
portal.
He hacked.
No, not hacked.
Then that's what I'm asking. He hacked what?
No, not hacked. It is an allegation made, not hacked.
Then I'm allegation how it will be done.
Because
No, allegation
something
is
there's
against
some
you,
wrong
right?
in the portal. This is his fault. That is that is a dispute between the informant and the ICI.
Like, understood. Now, how he has the allegation is that some profile has been changed, correct?
yes.
And now how it has been changed? How many? There must be some allegations in the
Yes,
FIR.
if you also go to page 6 and 7,
Page-
6 and 7, I will state everything.
In the FIR.
In the portal, Lordship,
Hmm.
the student needs to register and
Correct.
email ID has to be given,
Hmm.
password has to be given.
So he has hacked what?
Yes, he has hacked the
Email ID.
informant's
No,
email
no,
ID and registered himself as the informant.
No.
That is the
not that,
allegation,
sir.
Lordship.
It is further stated the allegation in the FIR that upon checking the recent activity section on Gmail account, the informer noticed that the device described as OPP AN 2020 has accessed his email account from Silchar in another manner. This is, but he does not.
Okay, right. After some manipulation in the email ID of the informant, the accused applicant had tried to change his profile available in the portal of ICAI, and also
It's 25,
Hmm.
Lordship.
and the details are alleged to have been hacked and tried to tried to manipulate with the admit card so that the informant cannot appear in examination, full stop. Full stop. Full stop, taking into account the allegations made and the allegations made in the FIR and after hearing the counsel appearing for the parties, this court directs that in the event of arrest of the accused applicant by the arresting authority in connection with Silchar PS case number 3062026, he shall be released on interim pre-arrest bail on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authority, subject to the condition that the accused applicant shall appear before the before the investigating officer within a period of 7 days from today, and shall cooperate with the investigation by making himself available as and when called for. Call for the CD, let the matter be listed on
12th August.
12th August. Don't do this kind of things. I mean, you are trying to, disturb your cousin brother.
May please, your lordship. This is PRS bail application, lordship. Allegation pertains to lordship, theft of lordship, crude oil, lordship.
Yeah?
Crude oil, lordship.
Theft of?
Crude oil, lordship. Condensate oil. Page 14, lordship, may I see the FIR? Page 14.
Bail rejection order, lordship will find it at page 26.
That is there, lordship. I am the owner of the lordship.
Page 28, lordship, paragraph number 8. The material change.
I am the owner of the lordship, the Tatayo, the vehicle, lordship.
Okay, we'll call for the CD, no interim at this stage. And heard Mr. N. Hassan Daran counsel appearing for the accused applicant, also heard Mr. B. Sharma Learned AP for the state. This is an application under so and so, call for the CD. Let the matter be fixed on
10th August.
10th August. Little bit earlier, maybe
Lordship, 7th August. lordship.
7th August.
Obliged.
6 to key.
May please, lordship.
May please, lordship. May prefer to take up the matter after some time. The case is led by senior counsel, Mr. Izzat Kamar, for the state of Assam, lordships. The case is led by for the prosecution led by the senior counsel, Mr. Izzat Kamar. It's another court, lordships.
Criminal petition for what?
Malat, for Malat, stay, Malat, challenging the order of Malat, attachment, Malat. Now, I'll just place.
Okay, let him come, let him come.
There's the fact first, Malat.
Let him come, let
Yes,
him come. Let Mr. J. Kamar come. then.
Yes.
This is not beyond the bar or done that lordship 19 days. Allegation only against them that lordship on 6/7/2026, Your Honor, for a petroleum party of the seized 19 number of kettle from the loaded car.
Okay, heard Mr. So-and-so, heard Mr. J. Your name is B. Islam.
B. Islam, lordship.
B. Islam, the learned counsel appearing for the accused applicant. Accused applicant also heard Mr. B. Sharma, learned accused applicant, so B. Sharma for APP. APP, this is an application under so-and-so, then call for the CD, let the matter fixed on
7th.
11th.
11.
All the cattle already is there, the
Hmm?
man, they are.
How many days there?
19 days, Lordship. They are not apply.
Okay, let the CD come.
And
Let the matter fixed on 7th July.
7.
Next is the question. I don't, this petition for quashing of the criminal proceeding matter pending against me matter, and two persons matter were substituted matter, and one person matter earlier filed matter one criminal petition for quashing of the criminal proceeding matter that has been allowed matter. I have annexed the order matter. If your lordship goes through the order matter, it will be clear matter page 22 matter. What matter 164 matter was. Yeah, sir. Page 22 and 11 person matter page 24.
Okay, heard Mr. S.S. Sikdar, learned counsel appearing for the petitioner. Also heard Mr. B. Sharma, the learned APP for the state. Respondent number 1, raise an application under section 528 of BNSS, 2023 for paying for quashing of the entire criminal proceeding of PRC number 2997/2021 under section 366 IPC arising out of Gauhati PS case number 126/2021 under section 366/380 of the IPC pending before the learned CGM Kamrup Metro. Let notice be issued to the respondent number 2. Let notice be issued to the respondents. A notice to respondent number 1 is dispensed with as Mr. B. Sharma, learned APP puts in his appearance. Notice to respondent number 2 through speed post. Steps to be taken within a period of 4 days from today. Today. What is this order?
Order mallet.
Page 21.
Page 21 mallet. Another mallet accused mallet who was also substituted.
Same case.
Yes, mallet, same.
Hmm.
So mallet he preferred criminal petition and that was allowed mallet.
Hmm?
So that was allowed mallet. So criminal proceeding mallet pending against him mallet that has been quashed. And mallet.
Only against him.
Yes, mallet.
It was quashed against him only.
Against him mallet. But
Hmm.
if your lordship goes to page 24.
Okay, we'll see. We'll stay the proceedings.
Mallet, kindly
In the meantime, huh?
PCR may be called.
PCR mallet.
Huh?
PCR mallet, and in the meantime the proceeding will be.
TCR in the registry to call for the TCR. In connection with PRC number 299/2021 from the court of the learned CGM Kamrup Metro. In the meantime, the proceedings under PRC number, the proceedings in relation to PRC number 299/2021 is stayed till further orders.
Okay.
Let the matter be listed after 3 weeks. Yes.
Is your lordship. This case challenges the order dated 21/5/2026, with which the additional Chief Judicial Magistrate chose to review the order dated 18/7/2025. The issued order, your lordship will find at page 13.
Please?
Page 13.
13.
Lordship will first come to the page 26, with which notice was issued to the accused. 18/7/25 order is at page 26. Lordship. This case was initiated pursuant to the disposal of.
So it was cognized pre-issue notice of pre-cognizance
Yes, Lord.
has been issued. Issued to whom? You?
The accused.
To the accused. Then what happened?
Respondent number 2 in this.
Hmm.
Thereafter, by the impugned order at page 13, Your Lordship, the learned additional chief judicial magistrate chose to recall that order by releasing it's the third last para, Lordship. The accused persons are released at this stage and the petition number 1085 is disposed of. After examining the complainant and his witness, if required, they shall be issued press notices.
What is wrong in this?
Lordship, even if there was some procedural mistake in the learned additional session judge by in her order dated 18/7/2025, that order she could not have, if she did the code, and presently the BNSS does not vest on her the power to recall. That power of review is not there, alien to the court. And Your Lordship's order has been referred to Bhupendra Chaudhary. But Bhupendra Chaudhary's case, it was with regard to the scheme, how it has to be done, the precognizance hearing. So, Lordship, I beg to refer to Subramaniam Seturaman, Lordship. 2004-13 SCC 324.
What is this order at page 28?
Page 28, this was the order passed in the writ petition filed by me, the complainant. In this case, what had happened was that the FIR that was lodged by the complainant before the Panbajar police station, it had had met with a closure report. That closure report was challenged before this honorable court. And on 8/1/25, by a detailed order, succinctly laid down the law with regard to the Honorable Supreme Court's order in Bhagwan Singh has also been discussed at para 7, Lordship. It was because of this proceeding that the CR case came to be initiated before the learned additional chief judicial magistrate. Back in 27/7/2012, the FIR was lodged, which met with a closure report.
Yes, what is Subramaniam Seturaman?
Lordship, para 11, if I can take your Lordship through. There the contention of the learned counsel for the respondent is recorded, in which he has submitted that the case considered by this court in Adalat Prasad case involved an offense which was triable in the warrant case. This court actually considered the power of the criminal court to recall its earlier order, bearing in mind the prohibition contained in section 362 of the code, presently 403 BNSS. He also submitted that the fact that Adalat Prasad's case involved the warrant case and KM Matthews case involved the summons case did not make any difference so far as the correctness of law considered by this court in Adalat Prasad's case is concerned. He also submitted that the appeal in hand being one tribal of as a summons case, the code has not contemplated a stage of discharge. Thereafter, my lord, para 12, then 14, 15.
Okay, read. Once the plea of the not guilty is okay. Having considered the argument of counsel for the so what is the ratio in this case?
Lordship, we see that this court, while dismissing para
No,
19
your argument is that once the notice has been issued by additional judicial magistrate, then he could not have reviewed his own order.
Yes, Lord.
That is your argument.
Yes, Lord.
So that is barred, you are saying.
362 CRPC,
403 BNS.
403 BNS.
Hmm.
The only remedy for the accused was to come before this court
I
by
thought it was
way of a
403 BN
528
without
petition
table.
to correct that order.
Hmm?
The only remedy that was available for the accused
To review before?
was to come before this court by a petition under 528 BNSS, praying for quashing of that order, 8125 order. In 7.
But this is not a final disposal.
Yes, Lordship.
This is
but-
only issuance of, only issuance of notice.
Yes, Lordship, but the
Whether that can be termed as this thing, final order.
that's an interlocutory order. I am not on that, but the accused has been released at this stage.
Hmm?
Accused has been released at this stage.
No, accused has been released, only because the order was passed. And you are challenging that order.
Yes, Lordship. If I can come to para 10 of Adalat Prasad, Lordship.
Let us see the impugn order again.
Page 13, Lordship. Accused is also present and has filed a petition stating that on the last date, the complainant had sought time to file documents in support of the protest petition.
Father
He has
is a
filed
brother of
his
the-
evidence by way of affidavit along with exhibited documents with a prayer to accept the same. Further, that it is stated that in view of the direction of the Honorable Gauhati High Court, the pre-cognizance hearing shall take place after the inquiry under section 223 BNSS and section 225 BNSS. And on 18/7/25, notice was issued to the accused for pre-cognizance hearing, but in view of the direction in Bhupendra Chaudhary, that's your lordship judgment, pre-cognizance hearing will take place only after examination of the complainant and witnesses. The accused persons are released at this stage, and petition number so-and-so is disposed of. After examining the complainant and his witness, if required, they shall be issued fresh notices. This virtually reviews the order dated 18/7/25 at page 26.
So he realized about this case later on. He realized about this Bhupendra Chaudhary case later on. So he reviewed his order. Is it so? I think he realized about this later on, after passing of this 18/7 order. Then he reviewed his order. So now your contention is that that review could not have been done. That power is not there. But he tried to himself, correct himself, but he cannot correct now. He is debarred from correcting himself, right? Yes, Mr. B. Sharma?
We are just a formal party.
Hmm?
We are just a formal party, Lordship. NIA case, but Lordship, my submission will be let the notice go, Lordship. Let the other side appeal.
Notice go, but he could not have reviewed this
But
because
that
this
is
is barred by, especially by this case.
We
I mean,
cannot review it.
he cannot review his order. Heard Ms. B. Chaudhary, the learned senior counsel, assisted by so-and-so for the petitioner. Also heard Mr. B. Sharma, learned APB for the state. This is an application under section 528, read with section 442 BNSS, read with article 227 of the Constitution, India, challenging the order dated 21/5/2026 passed by the learned additional chief judicial magistrate, Kamrup Metro in CR case number 324/2025. The learned senior counsel submits that that CR case number 324/2025 was registered before the additional CGM Kamrup Metro, and the same was taken up on 18/7/2025, wherein by order dated 18/7/2025, notice was issued to the accused. However, on an application, on a petition filed by the complainant on 21/5/2026, the learned additional chief judicial magistrate has in fact reviewed his earlier order dated 18/7/2025, whereby the accused persons were released and 21/7/2026 was fixed for initial deposition of the complainant. Full stop. The learned senior counsel submits that the power of review is not there with the additional CGM, with the learned additional CGM Kamrup to review its own order. In that connection, she has referred to the case of Subramaniam Sethuraman versus State of Maharashtra and another, reported in 2004 13 SCC 324. After consideration of the argument and perusal of the case of Subramaniam Sethuraman in Supra, this court is of the opinion that the proceeding of CR case number 324/2025 be stayed until further orders. Let notice be issued. To the respondents. Notice to respondent number 1 is dispensed with as Mr. So and so put in his appearance. The notice to respondent number 2 by speed post. Steps to be taken within 3 days. Then within 4 days, then it write TCR in the instant case. TCR in connection with CR case number 3, registry to call for TCR in connection, copy of the TCR in connection with CR case number 324/2025 from the court of additional CGM Kamrup Metro. Let the matter be listed after 3 weeks.
Main business. But I was application, I'm challenging in an FIR, well, facts leading to the filing of the FIR is, the petitioner, are the directors of Jalinga Tea Station, Jalinga Tea Company, Now, Assam Tea Corporations, as they could not run the tea gardens, they have, but they, invited the people, those who can run. Accordingly, I have been awarded 2 gardens. Your Lordship, kindly see page 22, Page 22. One is, Saikota Tea Estates and Nagarijan Tea Estates.
One is
Your Lordship will kindly see Saikota.
page 22.
Yes, page 22, That is at page 22, Your Lordship will find.
Okay, Saikota
And Nagajan.
handover tea gardens pertaining to Jorhat packet namely.
Long-term lease.
So this was done by the ATC. Okay,
80C,
then
my lord.
what
And,
happened?
my lord, these are the money which has to be, we have to deposit when, my lord, how it has to be deposited.
Correct.
Now, your lordship will kindly see, then, now Saikota Tea Estates, my lords, what happened while we went there, my lord, one, if your lordship kindly see page 27, my lord, we have written to the chief minister that regarding the Saikota Tea Estates, my lords, page 27, last part, my lord.
Why have you written to Chief Minister?
My lord, he is a,
How Chief Minister is involved?
my lord, he invited all this to run this Assam Tea Corp.
It is Assam Tea Corporation is invited. How
Lord,
Chief Minister?
We have just informed, my lord, your lordship, kindly.
The managing director is Rakesh Kumar Agarwala.
Yes, my lord, your lordship, kindly see section, page.
So why do you go to Chief Minister?
No, we have given a letter apprising to what is happening, my lord. We have also
Page
issued a letter, page 27, my lord, last part, my lord. In lieu of all current happenings with a heavy hearts, with request to release the lease only for the Nagarajan. My lord, what I said, I want to stress on that, the lease for the Nagarajan Tea Stage only, my lord, not Saikota, my lord. We are not interested because of the Saikota, because of the problem with the laborers. Now, if your lordship will, this again.
You have not written because you have not written Honorable Chief Minister Ji. You should have written Honorable Chief Minister
that's
Ji
a different thing.
because you have written Rakesh Agarwala Ji.
No,
So that is the reason. I mean, you have not been given any relief.
Maybe, my lord.
You do discrimination.
My lord.
Article 14 violated.
My lord,
You write against somebody G and somebody not G.
Definitely, my lord, maybe, my lord.
Yes,
And,
then in the
and thereafter, my lord, if you'll also say, then, my lord, Jalinga, my lord, we have requested for release of, so far Saikota is concerned, my lord, the state concerned, my lord.
Okay, so you said that there are some certain problems because of that. Saikota should not be given to you only Nagonizan.
Nagonjan.
So what is there any formal this thing written to cancel this?
No, these are the latest.
See, these 2 gardens have been allotted to you after following the due process.
Due process.
And certain conditions are there about the
Yes,
financials.
My lord.
And financial conditions are laid down there.
There.
Now a thing happened that, after taking the position, you are saying that no, this garden is not good. I won't be able to run it, so you take it back. That is your contention, right?
Yes, my lord. Yes,
so now, before quoting for this, before coming ahead to run those things, you must have taken the stock of the happening there or the status of the gardens.
Right, lord. That's which led to the filing of
the
FIR, my lord.
FIR. See,
Then what Jalinga Tea, my lord, we are the company, my lord. Now, once we taken, there are in the factory, my lord, there are rolling machines are not in working properly.
That you should have checked.
But, my lord, once I handed over. Now, what has happened, my lord, if your lordship kindly see.
Now, where is the FIR?
My lord, I'll come before that, your lordship.
No, it's not with the FIR.
I'll come to the FIR.
What is the alia? What are the
allegations, my lord? Allegations is by whom, my lord? It's absolutely a civil case turned to a criminal case, my lord. By proprietor of Tirupati Engineering Works, my lord. What it's written, my lord? Yes. Against all these directors, my lord, this FIR has been filed to the officer in charge, Jokhalabunda PS, my lord, Your Lordship, from 39 page onwards, my Lord, with above reference, I beg to inform you that I am a permanent resident of Jakhalabandha and a proprietor of Tirupati Engineering Works situated at Jakhalabandha, so-and-so, 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 involved in executing the work orders, installing, repairing of tea factory machines, and that it works orders from the aforesaid accused person Sri Ketan Patel, accused number 1, personally visited to our workshop and requested us to repair the plant and machinery of Saikota Tea Estates, which is under is and so control about the Jalinga Tea Company India Private Limited in April 2023, my lord. He promised to look into all our bills and clear them, repairing factory machineries of Saikata Tea, which was under control of accused person so-and-so, so-and-so, so-and-so. The following and due completion of all works orders to the satisfaction of all accused person, well, these are the on which date so-and-so bill has been raised, my lord. Now, the company wise Jalinga Tea Company India Private Limited, to which the accused person agreed to pay initially, but later on refused to pay the same, misappropriated the repairing machineries for their own use and cheated me by taking my huge investment in the repairing works of machineries and breaching my trust for the said contract works for the accused person. Despite of repeated requests and communication, accused person has totally refused to make me payment of the aforesaid amount by which the hard-earned money, and now I have no funds to run my firm due to the malafide acts of accused person. This has also been caused loss to the government as they are evading taxes through non-payment of GST. Further, the accused are advisory affecting law and order of the so-and-so, affecting rotation and local.
Mr. Bora, I mean, we will issue notice, but there will not be any stay on this.
My lord, your lordship will kindly bear me 1 minute. My lord, your lordship, under
No,
which
I mean,
provision of law?
yeah.
Under what provision?
This is purely a case of cheating.
No, how, my lord?
Purely a case
My
of
lord,
cheating.
my lord, how cheating? Your
You have given your machineries to be repaired. You have stated that you will pay the amount. You, after that, in spite of passing of 4 years, you did not pay him the money. Is it not cheating?
No, my lord.
Whatever financial conditions you have, you go through whatever problems, that doesn't matter at all. You have cheated him. That's all.
No, kindly one thing, your lordship will kindly go through one thing, my lord. Your lordship may kindly.
So that this is a case to be investigated. So we will issue notice.
No, page 33.
We will issue notice. There is no interim order in the proceedings.
Just give me a 1 minute.
Yes, yes.
Page 33, my lord.
33, yes.
33, my lord. To the
Yes.
Tirupati, so-and-so, my lord.
33, yes.
What we have written to him, my lord, 33, and that is on 2024.
Yes, what have you written?
You are aware of, yet we took Sayakota Tea for operation of management of the tea created so-and-so from the owner of the tea state, Assam Tea Corporation Limited so-and-so. We have returned back, my lord. Kindly see, that is on 24, my lord, we have given a return back.
You have returned back on when? 23/12/2023.
Yes, my lord.
And when did you issue a work order to him?
23 itself, my lord.
Then?
Your lordship, kindly see.
Then if you are anticipating, see, if you were anticipating that you will be returning by the tea garden, then why you engage him for this work?
My lord, just appreciate one thing. Lordship, kindly see, there is one is cheating and one is criminal breach.
That will be considered when the matter is properly heard.
Yes.
But at this stage, I am not trying to convince.
Lordship, kindly see, we therefore, my lord, requested, it is a case of a filing of suit, my lord, recovery. If you want to make a recovery, my lord, where is the question of
We
cheating, my lord?
understand what is recovery, what is cheating, and what is, intentional thing. It is not that like
that is why
this court is sitting just like
definitely
doing nothing. So we understand this, and what is civil liabilities, what is criminal liabilities, we understand. And what I am saying is that this court is not going to stay the proceeding. This court is going to only issue notice in this case.
Definitely, my lord, your lordship, kindly see, there is another. That is why, my lord, in this type of cases, my lord, in this type of cases, your lordship will find there, my lord, so for the 420-406 regarding these things, my lord.
We understand that.
My lord,
We understand that. But prima facie, the court is convinced that there are certain elements of criminality here.
Actually, in 2023, we have handover this one, and what quoted is the machines and others are also lying with them also, Assam Tea corporations. that have I been misappropriated, that I have been taken, that's a different thing, my lord. Your lordship will, my lord, why I have referred this, my lord, judgment of Delhi Race Club, my lord.
1 second.
Not only that, my lord, we have already also stated.
Why this poor person will suffer because of your this thing?
Well, the poor
Why he will
person- no,
suffer?
Now, how
He has engaged
no,
people,
how-
he has
how
repaired
he
your
has
things,
dressed, my lord.
and now you're
My
saying
lord,
that like, I will
my
not take it back.
My lord, he has a remedy, my lords. Now,
Oh, no, that
criminal
will-
case
that will
state
be
in
come later
motion
on.
by way of a false and fabricated FIR, my lord, lodging these things, my lord, which that then where is the civil courts, my lord? Now, if your lordship kindly see the Delhi Race Club, my lord. That is, this case has been registered under section 415 and 420, my lords. 420 and 406, my lord. Criminal breach of trust and sitting, my lord. Exactly what has happened in Delhi Race Club also, that exactly what has happened, that there, this,
Which paragraph, which paragraph?
my lord, now, if facts, if your lordship has to see the facts first, my lord.
Yes.
The facts is exactly like me, my lord. If your lordship see the facts, my lord, the complainant, it is most respectfully, that is at page 697, my lord, paragraph 4. The most respectful that the applicant so-and-so, Agara so-and-so, late so-and-so, who is the owner of firm, Agara Widow New Mandi so-and-so, applicant firm used to supply horse feed, barely one was so-and-so, New Delhi, since 1990. In the year 1995, then head of the race club, so-and-so, and the then Secretary Segal told the applicant that from the now on, the bills for supply of horse, grains, and oats would be made in the name of Delhi Horse Trainers Association. Now it has sent to the Trainers Association. I have been paid bills since 2017. Thereafter, this association, neither they have responded to that, nor they are paying the bills. So they have gone to the court and filed a complaint cases, my lord. Therefore, my lord, it has been registered under section 420 and cheating, my lord.
1 second, 1 second. Yes, yes.
My
Facts.
lord, now the facts exactly same to us, my
Then-
fact, my lord.
then-
Then your
then-
lordship kindly see paragraph 36.
It's not exactly same to us, but anyways, yeah, that is your submission, yes.
That
yes.
is, my lord, there is a my lord, Delhi Boat Club, and this is an association, my lord. They are from the same, my lord, club, my lord. Now, paragraph 36 has been defined. What is 420 and 406, my lord, is there. There's a distinction different. One is pre-minded and is post-minded. They cannot,
Correct,
they cannot go together.
intention has to be there.
Now, what has been discussed here, how it has been dealt with, my lord. Now, your lordship will kindly, last paragraph, what the Supreme Court says, is very important, my lord. Now, your lordship kindly,
1 second. 420 and 416 I have seen.
my lord, your lordship kindly see the last paragraph of this, what the conclusion of the Supreme Court is judgments. Now, what instruction has been given to the last paragraph, my lord, paragraph 54 and 55, my lord, your lordship will get to know what is there, and there's a, my lord, caution to the police officer not to register this type of cases, my lord. Now, what it says that when dealing of the private complaints, the law enjoins upon the magistrate duly meticulously examine the contents of the complaint so that as to determine whether the offense of cheating or criminal breach of trust, as the case may be made out from the averment made in a complaint, the magistrate must carefully apply the man's of mind to ascertain whether the allegation as stated genuinely constitute this offense, specific offense. In contrast, when a case arises from a FIR, this responsibility is of police, my lord kindly see, to thoroughly ascertain whether the allegations levied by the informant indeed falls under the category of cheating or criminal breach of trust. Unfortunately, it has become a common practice for the police officers to routinely and mechanically proceed to register an FIR for both the offenses, the criminal breach of trust and cheating, on a mere allegation of some dishonesty or fraud, my lord, without any proper application of mind. It is high time that the police officers across the country are imparted proper training in law so as to understand the fine distinction between the offense of cheating vis-a-vis the criminal breach of trust. Both offenses are independent and distinct. The two offenses cannot coexist simultaneously in the same set of facts. This is antithetical to each other's two provisions of IPC. Now, BNSS are not twins and they cannot be survived without each other's. In view of so-and-so, appeal so-and-so. My lord, this proposition of law has been laid down by the Supreme Court with a direction to the police also. They should be very cautious while, my lord, registering case, my lords. Now, how 420 sitting? Then the civil court, where the civil court goes? Admittedly, yes, we have given a distinct, we have handed over, there's a bill raised, we have said that we will help you to get it bill done from the Assam Tea Corporation. There's a dispute regarding, I am not saying that we are not paying the bills. Now, where the question of cheating is there, and what we say that an hour later to Tirupati Engineering, saying that we therefore requested to raise your bills. And we immediately, we said on 24, when he raised the bills, we say that bills for outstandings of Saikota Tea Estate to the ATCL authority, who are the owner of the Saikota Tea Estates along with the factory situated in the said tea estates, all machineries, we further clear is that we are not liable to pay any amount money for the said work orders, but if you want, we can assist you.
Why you are not liable?
No, no, but that.
Why?
Well, my lord, see, that has been taken over, but there is no lease deed has been executed against us, except negligently.
You are the person who has given the work, entrusted the work. Now you are denying, you are saying that we are not liable. What is this? That means like your intention is not good.
No.
Your intention was never good.
Well, if your lordship is sitting 415.
415, yeah, Mr.
415,
Mr. Bora. I mean, you have been repeatedly saying 415, 416, 420. We are aware of this.
My lord.
That intention has to be there. We are aware of this. But we'll have to see the facts here. So facts is what? You have taken the garden. After taking the garden, you are saying that like, the garden is not proper. I won't be able to maintain it. So you wanted to return it. That in the meantime, you have entrusted the work to some person, some poor fellow you have given the work.
No.
Now the poor fellow has done the work. Now you are saying, no, we won't be able to. You're directly saying, denying this, that I'll not be liable to pay.
No.
What is this?
No, we say that some tea corporation, because lease has not been done and we have already.
Whether lease has been done or not lease has been done, that's a different matter altogether.
We have to pay the money to the government, Assam Tea Corporations, and that's what we have said that. And exactly this Delhi Race Club,
See, Delhi Race Club case is that this vendor was giving horses to the race club from a long time, and they have been paying the money to him regularly. But once or twice they failed to pay, and they have been assured that the vendor was assured that we'll be paying it, but it was not paid. That's why he filed the case. In that case, there is no intention. I mean, there is no intention can be made out because that relation is already there. But in this case, there is no relation between you and the vendor. You just started the work.
I want to submit before your lordship that in Delhi Race Club was what? There is an association of the same.
Correct.
Same Delhi. Now, what has happened? Till 17, they are getting a bills. After that, Delhi Race Club said that now, so far, it is the feeding of this thing to the association.
Correct.
Because now they have.
It has been shifted to somebody else.
Now, association said that we are not going to pay.
Correct. Now,
We are not going to
since
pay.
it has been transferred to it has been taken over by a different association.
Now, here is the case, but here is the case, Milord, what has happened? Here, these two gardens has been entrusted to us. While we ended over, so we have to do such repairing to run this thing. Then we have seen that accordingly, we have given an orders now. And what we get an orders, Milord, they repaired it. When it has been repaired, Milord, we have already, handed over that. So for the Saikata is concerned to the Assam Tea Corporation.
Just show me that.
Well,
Show me that when the repair was already, repair was done, that we are, then before that you have handed over the tea garden.
no, no. If you're the letter which we have been written to, will not to Tirupati engineer.
Let us go to the dates.
Well-
The first date is at 28/3/2023. You were handed over the tea gardens, correct? Correct.
Well-
15 December 2023. You have written to the chief minister along with other persons,
No.
saying that please advise at the earliest we need to lease. We need the lease at the earliest. We are unable to continue any further without bank limits. So you are seeking for a lease, correct?
For Nagarajan.
Where is that?
My lord,
You have not mentioned that.
then, my lord, then
See, greetings from Jalinga so and so. Thank you for personal meeting so and so so and so. Okay. Unfortunately, things totally changed. For the region known to all, and so and so put on hold. NRDGA. What is this NRDGA? Assured by that NRGA can start at both estates. Yes. Then we have also taken new planning so and so so and so. In the meantime, we were successfully finalized 5-year long-term lease and so and so plantations to exist so and so so and so. Nagarjuna union workers are excited about this long-term development strategy and want to support us, but unfortunately, Saikata unions are not in agreement with so and so. In lieu of all current happenings with a heavy heart, we request you to release the lease for only Nagonijan TE, as unfortunately Saikata Union Specialist so and so division does not want any development to happen and do not want to support us in our. So you have requested
Well,
to release.
now, my lord.
Okay, now what happened?
Now, your lordship kindly see to Bishop.
Now you have written another letter on 18 December, 18 December on 2023.
Right.
Then
On December 22 also,
22
I have
also you have
a
written
letter addressing to all
Chief
Assam Tea
Minister.
Corporation,
Correct.
Rakesh Agarwala
Hmm.
to Assam Chief Secretary. And
So,
my lord,
so when was it formally taken over from you?
immediately thereafter, my lord.
Where? From where you are saying so? You are aware that we took Saikata Tea Estate in April 2022. You have 24. You have written to them. You are aware that we took Saikata Tea Estate for operation and managing of tea estate in the month of so and so from owner of Tea Estate Assam Tea Corporation. We have returned back the Saikota Tea Estate to ATCL on 23/12/2023. In the meantime, with the information to ATCL authority, we gave some order for repairing of the factory machinery for the Saikota Tea Estate on behalf of ATCL. The said machineries were not used by us till the tenure, and we operated the said tea estate. The machineries are kept by the present Saikota Tea management, and ATCL authorities may use the machineries. Even the lease of Saikota Tea Estate has not transferred in the name of Jalinga.
Now, my lord, your lordship will kindly page 36, what we had written to the managing director. My lord. If you would like to see the intention, my lord, the managing directors to page 36, my lord, to the managing director, Assam Tea Corporation Limited, Dispur, Gauhati. So with reference to a letter of the managing Chinamara so-and-so, reference number so-and-so, regarding details of Chinamara is also our garden, my lords. Details of the rolling table preparing Mrs. Saikota Tea Estate. Firstly, 6 rolling tables are in the scrap condition when we took over the Saikota Tea Estate. We have been informed by the vendor, Tirupati so-and-so, who had repaired rolling tablets of the tables of the Saikota tea, that no brass has been removed from existing rolling plates. The rolling tables was in a very bad condition, and while repairing the plates, rolling tables, the portion of the existing brass has been kept as unusual, and remaining necessary parts of the plates repaired the steel plates as it was most advisable. We have also informed that the 4 rolling mirrors has been delivered to the reinstalled Saikota. Some spare parts of the 5th are delivered to the Saikota so-and-so, so-and-so. That is what we have been stated to Assam Tea Corporations, my lord. And Assam Tea Corporation, what we have, they have given to me, managing director, to managing director so-and-so, that is a paste. We stated before details of the rolling tables, Secretary so-and-so, total so-and-so, so-and-so, these are the, after repairing, F. Dalinga Tea Company brought back for so-and-so, from so-and-so works, Jokhalaba incomplete and some spare remaining, 2 numbers of rolling tables and so-and-so in the workshop. Presently, these are 4 rolling base tables compressed, which is running condition in psychotatis as below, so-and-so, so-and-so. So, if your lordship will kindly see, and also, my lord, your lordship kindly see the intention of our intention that we have written to that. We say that no, we don't say that we do not going to pay you. And in fact, we wrote Assam Tea Corporation regarding giving of payment to them. So had it been an intention to do for cheating, my lord, definitely we will not do these things.
Yes, Mr. Sharma, you
Yes,
have anything
Lordship.
to say?
Yes, Lordship. So I have placed the judgment, if Lordship kindly takes the
Mhm.
judgment. It's the same case, Lordship. Lordship will kindly take up the paragraph number 2, Lordship will see it also challenges the 482 application, Lordship, for quashing the cognizance which was taken under 406 and so on, Lordship. Now, Lordship, paragraph number 3, Lordship will see the dispute arises from contractual and financial dealings between applicant and construction work. Some was undertaken and dues was taken and it was not given. Lordship will kindly come to paragraph number 24. 24, Lordship has found it.
24.
Yes, 24. It has discussed every aspect, Lordship. The appellant's core contention that the dispute is purely civil in nature is untenable at this stage. Although courts must guard against civil giving criminal color to civil dispute, it is equally well settled that the existence of civil remedies does not preclude criminal prosecution where the allegation disclose the essential ingredients of an offense. Civil and criminal proceedings may validly coexist if the factual matrix supports both. Next paragraph, Lordship. In the present case, the material on record, including the FIR and the charge sheet, contains specific allegation that the appellants induced respondent number 2 to undertake substantial construction work. So this is important, Lordship. And thereafter, Lordship, it stopped the payment. The appellant's reliance on the disputed no due certificate does not advance the case for quashing. Respondent number 2 alleges that the certificate is fake. So and so, we are not going to this. Quashing cannot be premised on disputed documents where validity is itself a matter in dispute. It also goes on to discuss, Lordship, this latest case, Pradeep Kumar Keswani, where the Supreme Court has laid down the steps for to be undertaken by the court while quashing a case. Lordship, if Lordship kindly takes up the paragraph number 27, Lordship will find in Italy, in Lordship has found it, paragraph 27.
Yes,
Lordship, yes. Lordship, this is the judgment of Lordship Pradeep Kumar Keswani. This court outlined a structured 4-step test to assess claims for quashing under 482 of the CRPC.
Correct. This is like this is in the final stage of hearing, right?
Yes. Now
we are at the very initial stage.
Yes,
and
exactly, Lordship.
and
Because,
we
Lordship,
need
this
to
will be
consider
even more
this.
difficult. Lordship,
We need
this
to
will be
consider this.
Quashing of this case, Lordship.
No, Mr.
even
Bora,
more
no stay at all. When you have argued a lot. Heard Mr. P. Bora, learned senior counsel, appearing assisted by so and so, the learned counsel for the petitioner. Also heard Mr. B. Sharma, the learned APP for the state. There is an application under section 582 of BNSS praying for quashing of the FIR and proceedings arising out of Joklavanda PS case number 92/2024. Registered under section 120 in capital B stroke 403/406 420/34 of the India IP 34 of IPC 1860. Then you write the learned senior counsel appearing for the appearing for the applicants, appearing for the petitioners. Petitioners submit that an FIR has been lodged against the applicants without any basis as no case of cheating or criminal breach of trust could be made out from a reading of the FIR. He submits that the accused applicants, he submits that the petitioners have been allocated two tea gardens, namely Saikota and
And Nagaraj, and
Saikota and Nagonibari. Nagonijan Tea Estate by Assam Tea Corporation Limited. However, since the Saikota Tea Estate was in a bad shape and it was not in a position to run, the same was returned to the Assam Tea Corporation Limited on 23/12/2023. He submits that during that period, certain machineries were directed to be repaired. Certain machineries were repaired in the workshop of the informant, and certain amounts of bills were pending. However, since the tea garden has already been handed over to the Assam Tea Corporation, the amount was not paid to the informant. Full stop. He submits that there was no intention of cheating in the instant case, and no criminal breach of trust has been committed by the petitioners. This is the payment. As far as the payment is concerned, the same has been already referred to, intimated to the Assam Tea Corporation, who has taken over the tea estate. In view of the aforesaid, he submits that the FIR has been lodged falsely, and there is no basis to file the aforesaid FIR. Taking full stop. Then you write. Then you write. Taking into account the submissions made by the learned senior counsel appearing for the learned counsel appearing for the petitioners, as well as the learned APP appearing for the state. This court is not inclined to grant any interim relief as prayed for in the instant petition to the accused to the petitioners. Let notice be issued to the
at this stage, my lord.
At this stage, let notice be issued to the respondents. Formal notice to respondent number 1 is dispensed with, as as the learned APP puts in his appearance for respondent number 1. Notice to respondent number 2 to be sent by way of speed post. Steps for notice to be taken within a period of 4 days. Let the matter be listed after 3 weeks.
Well, 3 weeks.
After 3 weeks, they come back. Let's see what.
Yes, my lord, your lordship will have to see the case diary also.
Okay.
Case diary is required.
Case diary will be required. Call for the case diary. Call for the case diary in connection with
Jokhalamanda PS case
Jokhalamanda PS case number 98 of 2024. 3 weeks.
Also, Millard, because it has been registered in the month of August, Millard, it has to be in DNSS. They have registered in IPC.
IPC, that is what.
That is also, Millard.
That's why while dictating, I got little. I had given little bit of pause, but sections given.
I have not stated, because the matter has been from July. It has been DNSS. Now they have registered under in the August, Millard.
Date may be fixed.
I know that.
We will look to call about the CD, but date may be fixed.
Oh, the date may be given. Okay, after. So I think you can get the CD little bit earlier also, because I have not given him any interim as it's
after 3 weeks.
I'm giving 3 weeks, but it can be 2 weeks also.
3 weeks also. 3 weeks.
3 weeks also did. Because since I have not given him any interim, so if you can make it little bit earlier, then court can hear it, and if you
we can make it earlier.
Then after 2 weeks you give it. 2 weeks, Mr. Bora. 2 weeks.
14th August, Friday. 14 August.
Friday no time dekho na to. Motion de hai.
12th August.
12th August.
12th August. Returnable on 12th August. Fixed on 12th August.
Yes. Right. Oh. My lord, the lordship will find, here I have been, I challenge it.
This, you want to keep it here or it should be on a record only? This- Will it be-
Let it be placed on a record, my lord.
Okay.
My lord, here in the case, my lord, I am challenging the order by which, by the fast track court has been, fast track,
Court,
Hmm.
exclusive fast track court.
exclusive fast track court,
Hmm.
by order dated, my lord, 29/4/2026, my lord.
My lord, with all respect, before he opens up the case, your lordship, by the last date, my lord, I'm just, on the last date, the order was that we have to file the objection. Our objection is almost ready, my lord, but today we could not file it, my lord. So I pray, my lord, that 1 week's time may be given, we will be carrying out the exercise. And the most important thing, your lordship, in this case, the LC is not called for, my lord, scan copy, my lord. That
Okay.
will be required.
A scan copy of the TCR will be
Yes.
required.
Not required, my lord. Why I'm telling you, it is regarding attachment, my lord. I can show and I can satisfy your lordship that how this order has been passed, my lord, violating absolutely 107, my lord.
But anyways, TCR will come from which court? This
No,
court?
no, TCR, no, TCR, what will it get it? But only things.
The
for the
records,
10
so
no, no,
that we
record
can
is what?
refer it, my lord.
Record is there, my lord, 107, my lord. What has happened, my lord? I just shortly, my lord.
No,
let
no,
it be-
no, Mr. But how is it going to prejudice you if the TCR is there?
No, no, I'm not, it's unnecessary, with the use
No,
all
No, no, no.
That
No,
is,
no, all is in pen drive, your lordship. The pen drives, TCR.
The volume may be very high.
Yes.
I mean, but
so for the attachment, we are only on the point of attachment, my lord. Only on the point of attachments.
Aji Hassan gate, right?
Only the applications, my lord. What has happened, my lord? There is an order by the deputy commissioner regarding, my lord, closure of my property, that is Mohabir Equa.
Not your property.
And also, one of the accused is a partner to my Mohabir Equa. I challenge these orders before the Honorable High Court under 226, that is an illegal. In the meantime, when we get to know that the order which passed by the Deputy Commissioner is illegal, they file an application in between under 107 BNSS regarding attachment. And in the High Court, my lord, they said that as we have filed a so-and-so, this writ petition became infractions. My submission was at that point of that, these two different things. This High Court has heard the matters and quashed this order, whereby sealing of my factory is concerned, my lord. Now in 107 proceedings, my lord, the notice, as I am the partner, neither am an accused nor, my lord, I am anywhere
But
related.
anyways, Mr. Bora, he's seeking for some time for objection.
Yes.
Let the matter be fixed in on next week. When do you want? 4th, 5th,
Any date, man.
4th? Because he's saying that he'll file today only.
Not today, my lord. Of course, it's not ready. Monday by a week, probably.
So
By
4th,
by
5th,
this week we'll
whenever
file.
you both of you agree?
I will not go through, my lord, I know everything, my lord, what he will, I know, because what the.
My lord, we are learner, my lord.
No, no, no.
He will-
So anyways,
I don't, the objection is on what, and I don't have to go through also.
We have to give an objection.
Definitely, I'll.
okay,
they have a right to
we'll
give an
fix on
objection to
4th of August.
They have a right to give an,
Heard
I'm not
Mr.
saying that.
P.
I will
Bora.
not-
So if I have the right, then keep quiet, we'll take it.
Heard Mr. P. Bora, the learned senior counsel, assisted by so and so, the
After fifth,
petitioner.
after fifth,
After 5th.
fifth.
Okay. 7th?
Well, after regular.
7th is on Friday.
But it'll take time.
6th.
Sixth.
6th. Okay, so and so.
No, 6th, I have some problem, my lord. Let it be on 10th, my lord, Monday.
No, Monday.
Yeah, 10 come on.
Tuesday, yeah.
Hmm.
You have
11,
Okay.
okay?
Heard.
My lord, on 11.
And also heard Mr. Jet Kamar, the learned.
Because of
senior
course, I
counsel.
will agree with him, my lord. There is a legal dimension also in this case, my lord.
Okay. Kamar.
Because this BNS are a new concept, so it has to, the law is yet to develop. So we are in the process of that, my lord. That's true. He has rightly pointed out certain thing.
Okay. Jet Kamar, the learned senior counsel, appearing for the state, assisted by Mr. P. Ratta. Assisted by Mr. P. Ratta. Mr. Jet Kamar submits that objection in this case will be filed. Will be filed. Will be filed. He is ready and will be filed in the next week. Therefore, he prays for adjournment of the matter and prays for listing of the matter on 11th August, which is not objected by the learned counsel appearing for the petitioner. Let the matter be listed on 11th August.
And in item number 20, my lord, probably the council is online, my lord. Same attachment order, my lord, regarding the other partner, my lord.
Item number 20.
20, my lord. If your lordship feels, or we can wait, my lord.
But he is not there.
Or probably he will be online, my lord.
Then
We'll wait.
we'll just pass an order in, I mean, in his presence.
Ah.
Huh?
We'll wait for the third, my lord.
Okay.
Matter is that, my lord, the petitioner and the respondents were the husband and wife.
Hmm.
The respondent wife filed one DVA in the year 2020, where one interim order was there for payment of some amount in the which was passed in the year 21. In the year 22, the wife filed one divorce petition before the family court on the ground of cruelty. In the year, during pendency of that case, in the year 2022, both the parties mutually settled and filed one mutual case, where one agreement is also there, my lord, which is a part of the record at page 34. So as per this agreement, other cases were to be withdrawn by this
Wife.
Yes. 4 lakhs full and final payment has been received already. That is at page 38. But the DV case is still pending. They are still pursuing for the amount, my lord. And impugned order is at, my lord, last page, 73.
Where is the out of court settlement?
My lord, kindly come to, not out of court.
Mutual settlement.
Yes.
That has been filed before the court.
Yes.
Where is that?
Page 34, my lord. And relevant paragraph is at, my lord, page 38.
So this has been filed before the courts,
Yes.
both the, huh?
Yes.
In both
And
the matters.
Judgment is at, my lord.
Okay, judgment,
Judgment
this
is,
has been
my lord,
filed, then where is the order?
Page 40. Page 40, last line, my lord. It also reflects the same. The
Page 40,
yes,
last
this
line.
is the order. Last line, it is stated
Stated the
that
petitioner
both
would behave
parties
with
shall
respect
have
to-
no further claim against each other. As per this agreement, my lord. So decree is passed already.
So decree is already passed.
Decree is at, my lord, kindly. Page 42. 43, last word, my lord, full and final amount. Petitioner number 2, that is the wife, has received an amount of rupees 4 lakhs from the petitioner number 1 as full and final amount. So this is a clear misuse of, my lord, law. She is duty bound to withdraw the matter, but that is not done. And still pursuing, and after divorce, she ceased to be my wife.
Wife.
Because of the decree of divorce filed by, earlier filed by her, subsequently mutually filed.
But domestic violence case, I mean, will cease to exist or only because the divorce has happened?
As because the agreement is also.
Correct. What is the law in that? The law in that?
Well, kindly come to section 26.
What does it say, read?
Relief in other suits and legal proceeding. Subsection 3. In case any relief has been obtained by the aggrieved person in any proceedings other than a proceeding under this act, she shall be bound to inform the magistrate of the ground of such relief. So as per that mutual understanding, as well as undertaking given by her, this is to be informed before the.
No, informing is fine. What I'm saying, what this court is asking is, see, I mean, there was a domestic violence case which happened prior to the filing of the divorce petition. And divorce petition was heard and it was decreed.
Yes.
Now what happens to the domestic violence case? I'm just asking, in your case, it is not involved. Yes, in your case, the things are a little bit different because you are saying that already a mutual settlement deed and that has been filed before the court, and in terms of that, money has been paid and all. That is fine. Anyways, we will notice on this. Heard Mr. Dean after the learned counsel appearing for the accused, appearing for the petitioner. Also heard.
No, my lord. This
No, you are not there.
DV case, pro notice.
So, this is an application under section P 528 of BNSS, praying for quashing the DV case number 65 M stroke 2022 pending before the learned judicial magistrate first class Kamrup Metro at Gauhati. The learned counsel appearing for the petitioner submits that a mutual settlement agreement between the parties in FC in bracket C 1646 stroke 2022 for mutual divorce, whereby the respondent wife had already accepted a full and final amount of rupees 4 lakhs as one-time settlement. He submits that in spite of the aforesaid settlement, the respondent wife has not taken any steps for withdrawing the DV case. What is this DV? Which is this DV case?
My lord,
DV case number?
Last page.
Huh?
Last page, my lord, impugned order.
Huh?
Last page is the impugned order. So case number is, my lord,
Not I want.
DV case number 65 small m oblique 2020.
Pending in
Judicial Magistrate First Class, Kamrup Metro.
Kamrup Metro. Full stop. Let notice be issued to the respondents by speed post. Steps for notice to be taken within 4 days for 4 days from today. Then we'll have to call for the TCR probably. Call for the registry to call for the TCR, scan copy of the TCR in connection to both the cases. It will be required.
It is, my lord may do it. Otherwise, I have already annexed it. However, my lord, as it is disposed of before the family court, that may be called for better adjudication.
The other case will do. Other case, there is no record probably for that. As far as your settlement and all, have you filed it there also?
Yes,
DV.
that is the.
Then I think that will do. Registry to call for the scan copy of the TCR in connection with which was DV case. Connection with the DV, write the DV case from.
DV case is
from
DV case number 65 oblique 2004.
From Judicial Magistrate First
Class, Kamrup Metro.
In the meantime, the proceedings of the DV case so and so is stayed until further orders.
Okay.
We'll just come back in 5 minutes.
May I say? Here in this case, madam, by page 15 order, the case is initiated, madam, registered initially under 376, charge sheeted, charge frame. Then, madam, the witnesses were called on the day when the impeachment order was passed as page 15 I have annexed. The informant cum victim appeared. But on that day, our petitioner's counsel was ill. He was suffering from illness. So because of his illness, my lord, he could not appear before the court. And your lordship will find page 15. This is the order. Page 15. Accused person such and such are present. PW1 such and such is present. Her examination in chief is recorded in my chamber, in camera trial, in presence of learned defense counsel such and such. Learned defense advocate such and such submitted that he is a junior advocate of Mr. such and such, and submitted a petition number such and such saying that his senior advocate is suffering from illness and they have prayed for adjournment. Learned advocate such and such has refused to cross-examine the PW1 in absence of the senior advocate. Now, section is quoted. In the instant case, the accused persons are present, their advocate has refused to cross-examine. This is not correct, madam. This is purely contrary to record. Their advocate has refused to cross-examine the witness on the ground of absence of senior advocate, which is not a valid ground. Therefore, we find it fit to dispense with the cross-examination of PW1 unless a cost of rupees 10,000 is deposited by the accused person on that day itself, my lord. If the accused person deposit the cost, today the cost shall be given to PW1 and remain present on the, with direction to remain present on the next day. In the failure, the deposit cost on today itself, cross-examination of shall be treated as dispensed with. So, therefore, we are before your lordship. The adjournment was sought for on the ground of illness of advocate. That ground is always considered to be a genuine ground in all the court. But this time, this court found to be very rigid on this, and that too, my lord, impose the cost 10,000 to be paid on that day itself. Therefore, I have very limited prayer, my lord. That order may be set aside. We are appearing each and every day. Last 1 year, no further witness come.
Yes, Lordship, kindly see, the charge sheet was submitted in the year 2024. And this witness, PW1, she was examined on 19/7/25.
July 25. And your lordship, then I will.
One second. Then
19/7/25. Now, Lordship, on that day, Lordship will find it at page 31 itself. The last part, page 31.
the deposition has been made.
Yes, cross-examination shall be treated as dispensed with. Lordship has already seen with under section 309 because the learned junior advocate Mr. Imran Hussain refused to cross-examine P1 today because absence of senior advocate unless cost of 10,000. That Lordship has already seen. Now, Lordship will kindly see the order. Why I'm stating Lordship, because the whole order sheet needs to be before your Lordship, because Lordship will find here in this page 35. Issue bailable warrant of arrest of rupees 1,000 against Vikas Chakraborty.
35.
So what was the cause of delay, Lordship? That has to be ascertained first, Lordship. Because apparently, Lordship, this order is of 4/7/26. So, Lordship, if the victim was examined in the year July 25, for 1 year, what has happened, Lordship, in this case?
No, nobody turned up. I have said,
No,
I received the instruction from my client and also from the conducting counsel.
No, that is not the issue, Lordship. The issue is, Lordship, PW1 was examined on 19/7/25. There is a specific order passed on that day to submit the cost of 10,000. What were they doing for 1 year, Lordship? 14/7/26. What prevented them from filing this application at that time or deposing the cost? Lordship, where is the explanation of 1 year, Lordship?
In my affidavit, I have.
They are dealing the case, Lordship.
I have category my.
No, you are delaying the proceeding.
Yes. No, not a single witness. If your lordship,
I'm not on witnesses, Lordship.
As my friend has submitted, my lord, if your lordship want to examine the record, yes, that will further delay the proceeding, my lord. But whether this ground is justified, I am under 482 now, my lord, it is 528.
That is
otherwise secure end of justice. Whether it is end of justice demand that a lawyer is, my lord, it is a 370. Your lordship kindly consider it is a 376 case, my lord. It is not a my lord small case of my lord marpit etc. My lord.
Exactly,
so,
Lordship.
Experienced lawyer has to be there, my lord.
Lordship will see this PW1 was examined on 19/7/25. So what has happened before that, Lordship? Where is the order sheet, Lordship? Why has the court passed this order, Lordship? There has to be some reason, Lordship. That has to be examined by your Lordship, because I'm sure, Lordship, the order sheet will reveal everything, Lordship. And Lordship, passing of this order imposing of cost, they come up before the court on after 1 year. Exactly 1 year.
We offered 5,000, my lord, that was refused.
This was a cost imposed, Lordship. Offer cannot be made, Lordship. They have to pay.
I leave it to your lordship, my lord. If your lordship want to examine the record, it will further delay the proceeding. In that case, my lord, I will pray for my interim prayer. I am not now praying for interim only. If your lordship, instead of 10,000, my lord, if your lordship decide, my lord, 2,000, all right. But my humble submission is that, my lord, ground of illness of advocate, my lord, cost cannot be imposed, my lord. This is a genuine ground, my lord. 309 itself.
Let him pay 5,000 rupees and we'll dispose of this and direction to allow him to cross-examine.
Lordship, one more.
Only thing is that like
additional-
order sheet is not there, but whatever may be the reason, I mean, see, senior counsel was not, I mean,
That is why, Lordship, I am submitting, Lordship,
Hmm.
because the conduct of the other, Lordship, the previous order sheet, there has to be something, Lordship. Otherwise, this court, Lordship, will not impose a cost on the first
but
date.
nothing has been written in the order.
No, the order sheet is not before your Lordship.
No, this order at least,
Something
at
might-
least something
Yes,
should
this
have been
order, it
recorded.
is not written.
Something should have been recorded.
Yes.
I have examined, my lord. Only 4 orders there. In between, my lord, from the impugn order.
No, before this impugn order, what were the orders?
After this impugn order.
No,
subsequent
before the impugn order.
So before
See,
the case was charged framed, and this was the first date for fixed for evidence on July.
19/7 was the first date.
Yes, was the first date for evidence. On that day, informant came.
Then Lordship will dispose of the application. Cost, I leave it to Lordship. Only Lordship will observe that there will be no further delay on
No,
their account.
definitely, my lord.
They are delayed.
Your lordship only record the, I also issued that.
Lord, Mr. Right, heard Mr. A.I. Within the learned counsel appearing for the petitioner, also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 528 of BNSS 2023, read with Article 227 of the Constitution of India. India, assailing the order dated 19/7/2025 passed by the learned additional session judge, Gauhati in sessions, case number 2. Sessions, in sessions, in case number sessions in bracket 249 of 2024, whereby the learned additional session judge rejected the prayer for adjournment made on behalf of the counsel who was suffering from illness and directed the petitioners to deposit a cost of 10,000 on that day itself. And in failure of payment of the aforesaid amount on that day, the cross-examination of the petitioner, cross-examination part of the PW1 would be treated as dispensed with by the defense. But Mr. This thing is a criminal case and cross-examination you are not allowing only because the counsel was not there. I mean, how justice will be done? Don't you think this is too, I mean, too immature? I mean, it's a 376 case and the victim has come and you are dispensing with the cross-examination of the victim only because the counsel was not present on that particular date, that too on the first date.
That Lordship is striking me, Lordship, because the complete order sheet we have to peruse, Lordship.
No, he's submitting
I'm not
that.
doubting him. I'm not doubting him.
He's submitting that this was the first date after the charge.
That I'm.
If that is correct, then this is too, I mean.
Yeah, then it can be said, Lordship, it's a bit harsh.
Harsh means like, I mean, the trial will be hampered. I mean, cross-examination you are not allowing. The persons will be, I mean.
Yes. He will be affected, Lordship.
The persons will be prejudiced. I mean,
Yes,
like that.
easily.
The learned counsel appearing for the petitioners submit that after framing of the charge, 19/7 19/7/2025 was fixed for fixed for examination and fixed for examination of the accused persons, namely Vikas Chakraborty and Umesh Basfar, the petitioners in the instant case. He submits that though examination in chief was recorded on the date, due to the absence of the senior counsel for his ailment, the junior counsel present had prayed for adjournment of the part of cross-examination by the defense counsel, who was not present to cross-examine the cross-examining the victim, that is PW1. He submits that though there was no failure on the part of the counsel appearing for the accused persons, and that was the first date when the matter was taken up for cross-examination. Matter was taken up for examination of the examination of the petitioners.
Prosecution.
Examination of the PW1. The learned trial court, in spite of giving an opportunity to cross-examine the victim to the defense counsel, had ordered for payment of ₹10,000, which is pretty high in the facts and circumstances of the case, and that too directed to be paid on the same date. Otherwise, the cross-examination part shall be dispensed with. He submits that the order is very harsh, as well as the same will hamper the fair trial of the petitioners. Full stop. This court has gone through the order that has been passed on 19/7/2025 and other materials brought before this court by way of filing this instant petition. (4/7/2026) available warrant was issued because of his non-appearance.
Petition number 2 was not present, but he will appear on the next date.
No, that is fine, but that means like there was some dates were there.
The next date is on 10th.
No.
Petition number 1 present.
No, you said that there was no other dates fixed prior to 19/7.
Prior to 19/7, the case was fixed for framing of charge. The
But what is the date of 4/4/7? Page 35?
Yes, 4/7 for further evidence.
No, 4/7 is prior to 19/7. That means there are certain other orders and the bailable warrant was issued to this petitioner number.
The 4/7/26.
Huh?
4/7/26.
Oh,
Let
26.
let us.
Okay, 26. Yes. What is the last line? This court has gone through the so and is of the considered opinion that the order dated 19/7/2025 should be set aside. Accordingly, the order dated 19/7/2027 is set aside. Full stop. It is directed that the petitioners shall be allowed to deposit an amount of rupees 5,000. 5,000. Huh?
He's
5,000 amount of
ice
rupees.
cream
five-
vendor, street ice cream vendor.
There are two persons are there. Two persons, 2,500 each.
One is
2,000, no, 5,000 is 5,000 by the petitioners, and same shall be paid to the victim. The direction was to pay
before the court.
we have paid before the court. Paid to the court. No, paid to the court. No.
Deposit before the court and court
Yeah,
will enforce it.
deposit before the court, and in next date, and a date to be fixed for cross.
Already fixed on 3/10/26.
Huh?
3/10/26.
And on the next date, the counsel for the counsel for the accused persons shall be allowed to cross-examine the PW1, that is the victim. In terms of the aforesaid direction, the instant criminal petition is disposed of. That will do.
I know. But in first paragraph, your lordship says fixed for examination of accused. It's fixed for examination.
Fixed for examination of
Prosecution.
PW1 victim.
I know.
And pass over this matter for the day, Your Honor.
On the prayer of the learned counsel appearing for the accused applicant, let the matter is as matter stands adjourned, and matter stands adjourned to be listed on listed after 2 weeks.
24, will hear. Wait, please, Your Lordship. Lordship, this is a regular bail application, Lordship, 135 days in jail custody, Lordship. FIR Lordship will find on page 14, Lordship. Just sheeted case, Lordship, PCR was lawful, Lordship.
Is here or received lordship, it is charge sheeted on 18/5/26 under section 22C and 25 of NDPS Act, lordship. So 10 PWs are there in the charge sheet, and next date is 31/7 for 26 production. So
31/7.
charge 31/6/7/26. So charge is not framed yet, lordship.
Now, Lordship, this petitioner, Lordship, is a lady, Lordship. He was arrested, Lordship, as per Lordship, the arrest memo issued under section 36 of the BNS, Lordship. Her arrest has been shown as 10 PM night. So, Lordship, so for Lordship, may I take Lordship, BNS, Lordship, 43/5. How arrest has to be made in case of a lady, Lordship. Because that arrest was made, Lordship, after sunset, Lordship.
How can she be arrested at 10 p.m. on 10 p.m. on 11/3/2026
Yes, Lordship.
when they got the report at 12 p.m.
Yes, Lordship.
and they went to the place, then did all this thing and and mm,
As per FIR, Lordship, it say 3 PM.
1 second. 10 p.m. on 11/3/2026, right?
Yes, Lordship.
And they mentioned that 10 p.m. Okay. 12 p.m.
Even if Lordship 10 PM, Lordship, that is Lordship after sunset, Lordship, and section 43 of the BNS says, Lordship, the woman, there must be a women police officer.
No,
here.
that we know. What we are trying to see, the incident, I think they have written 12 p.m., but it should have been 12 noon.
12 noon.
Correct. So 12 noon till 5 p.m., 5:20 p.m., they have, they have been searching or whatever they are doing.
Yes, Lordship.
So they have taken her under control, under their control by daytime only.
Yes, Lordship.
Only arrest is shown as 10 p.m.
Yes.
So that means she has been arrested before sunset.
But the arrest memo but the arrest memo, Lordship, is reflect after sunset.
So there must be something.
Lordship, it is after sunset.
But the arrest cannot be said to be at 10 p.m. then.
It is their document, Lordship, 36 notice was issued, Lordship, specifying, Lordship, 10 PM, Lordship. They have to taken permission from the magistrate, written permission, Lordship. Arrest that lady after sunset, Lordship.
In a FIR, Lordship, immediately the matter was informed to the OC Badarpur Police Station, who stated that he would come to the spot to supervise the seizure at around 3 PM. After completion of all due formalities, I, along with the staff, departed from the place of occurrence.
No, what due formalities? Have you taken the formalities of fulfilling the formalities of 43?
They have arrived at the police station at 5:20 PM.
Mr. Goswami, you check the thing properly, whether any permission has been taken. We'll take it up after some time.
Yes.
All right.
You check whether 43 permission has been taken or not. Otherwise, you cannot arrest somebody, a lady, after a sunset. That's a settled law. But a search was done at 12 p.m., 12:12, and after that, that police went to the police station, went back to the police station at 5:30.
Yes.
That means she was taken under control. Because her house was searched, and she was there. So she must have been arrested before. Now, how police can report it at 10 p.m.?
Okay.
Mr. Sharma, how can it be done? See, the police went to the place of occurrence at 12 p.m. Daytime. They went to this lady's house and they recovered certain amounts. They completed all these formalities by 5:30. They went back to the police station. Then it's shown arrest at 10 p.m. at night. Check it.
POCSO service is complete, Lordship. We have received the report.
When it was executed? Any? RRE, the learned counsel, if any for the accused applicant, also have Mr. B. Sharma, learned APP for the state. Mr. Learned APP for the state submits that service upon respondent number 2 has been executed on 23rd, 23/7/2026 in view of the aforesaid. Let the matter be listed on 6th.
28, today on 48 days.
Huh?
Today 48 days, my lord, and prime accused has already been released.
My-
8 days.
Some photos were printed out.
But
from my
48 part is a POXO matter.
POCSO 14, my lord.
Hmm?
POCSO 14. Even not applicable in this case.
It is 60 days.
Lordship,
Hmm?
60 days.
Then playback matter will be fixed at
On 28, my lord. Or 20.
28 will be too early. 30th will be.
26.
This charge sheet submitted also.
You go and appear there.
Started my call for lot.
No, you
Yes,
go and appear there. What is there?
Lordship, in my petition, Lordship, paragraph 7, Lordship, may peruse, Lordship.
Hmm.
Lordship, the petitioner, arrested person is not the FIR name accused, Lordship.
So you go there, go to charge sheet has been submitted, you go there, you go and appear. We'll give you the liberty to go and appear.
Lordship, I already arrested and I am alleged in jail.
Oh, he's in
Lordship,
jail.
Lordship, I am not the FIR name accused.
Hmm.
And last order, Lordship, DNA test, profile report was called for.
Hmm.
Lordship, charge sheet may be called for, Lordship. TCR may be called for, Lordship.
Okay. Heard Mr. K. Islam, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned APE for the state, as well as Mr. I am it for? I am in for the respondent number 2. The learned APP submits that charge sheet in the instant case has been filed. Instant case has been filed by charge sheet number is
142/26 dated 28/6/26.
Registry to collect, registry to call for the charge, the TCR in connection with Godso police case number 289/2025. Which court?
Lordship,
Charge sheet filed in which court?
no, sir, last time we are not filing any.
Now charge sheet has been filed
Can you
before
submit
which
for a
court?
court along with
Special just Kamrup Metro.
Before from the special, from the court of the learned special judge Kamrup.
Lordship, along with
And
DNA
the
test
POXO case has
profile.
been registered.
POCSO
I
case
mean,
is POCSO 6.
Huh?
Under POCSO section 6.
Then any case has been registered before, after the charge sheet?
No, only we have received the information regarding charge sheet and
Okay.
charge sheet number. Lordship.
Lordship, along with DNA.
My lord, I seek a week's time to place our objection in this case, 27. The brief is still not been handed over.
You are appearing for
NCB.
CV. Copy has not been given to you.
My lord, that is prior to me, learned Deputy Solicitor General, Mr. Ranjit was handling the case, but he's on leave right now. It is reflected in the cause list as well.
What is your name?
I Singh, Inderjit Singh. Inderjit Singh.
Inderjit Singh.
Yes.
You don't usually call, the council by their first names.
I apologize, my lord.
And that too, he is a Deputy Solicitor General of India.
Deputy,
Please maintain those things.
my lord.
He is not your friend.
Yes, ma'am.
He may be your friend outside, but not inside the court like this. Okay, heard Mr. A.K. Talukdar, the learned counsel appearing for the accused applicant. Also heard Mr.
I Singh.
I Singh, the learned, your standing counsel,
Yes, ma'am.
learned standing counsel for NCB. Mr. Singh submits that he doesn't have a copy of the bail application, and they have done the bail application and prays for some accommodation for filing the objection in the instant case. The counsel for the counsel for the accused applicant is directed to serve a copy of the bail application to Mr. Singh during the course of the day. Let the matter be fixed on
So maybe next week, my lord.
Fixed on, you serve him a copy, he'll require some time to go through it, then he'll file an objection. So I think we should fix it sometime around 6th of August.
Hello.
Let the matter be fixed on 6th of August. In the meantime, the council, for NCB shall file the objection in the instant case.
My lord, maybe on 5th.
5th, Mr. Singh, okay? 5th. So you file an objection in time.
28 Lordship, as per office note dated 22/7/26, service is not completed. Service report not received yet.
Heard MSSC Borwal and counsel appearing for the accused applicant, also heard Mr. D.P. Goswami and APB for the state. Office note dated 22/7/2026 reveals that service report regarding service of notice upon respondent number 2 is yet to be received. Let the matter be listed on 5th of August. 5th of August.
My lordship.
29 days.
29.
Is there any?
Vigilance Rajwa received, but service report not received yet, Lordship. Service is awaited. Step was taken, Lordship.
Okay, service report awaited. Let the matter be listed on 5th August.
30.
Service report not, service report is awaited. Let
Also,
the
we have not
matter be
received the
listed
case
on-
diary also.
Huh?
We have not received the case diary also.
Let the matter be listed on
But please, also 83 days in custody, Lordship.
83 days
Yes, Lordship,
already.
already.
So we'll fix it on 31st, 31st July.
Lordship. Deeply, Lordship.
31.
May it please the Lord. Here also not 50 days behind the bar, my lord. Section 12 of the POCSO has been added, my lord.
So I have prayed a prayer, Lordship, made a prayer, Lordship, for another date.
The INF offense are all.
Service also not complete.
Service also not complete.
Service also not complete. Service is awaited. Service report is awaited. Let the matter be fixed on.
30th, my lord. 30th, my lord.
31st will be first week August.
Already 50 days, my lord.
50 days.
Or 60 days offense.
In 31st basically. Let the matter be fixed on 31st. 31st, how many days will be there? 2 days.
2 days.
Already 50 days.
It will be 57 days.
Huh?
It will be 57.
Okay, then fine. 30th will fix it. 30th, 30.
30.
32. Wait, please.
My lord, in this case, there are 4 accused persons.
Is that he has come?
Yes.
2 have already been enlarged on bail, my lord, by the trial court. My lord, actually, no overt act has been alleged in the FIR. It's not that, my lord, that they were caught while attempting to commit an offense or something. But lordship should kindly come to the FIR. It's at page 15.
You were named in the affair.
I'm named in the FIR.
And you were inside the jail for how many days?
Since 36 days now.
36 days.
And there are no victims, my lord, in this case. Therefore, the filing of charge sheet will unduly take long time. Kindly see, my lord. And the alleged co-accused were released on 3rd of July. My lord. I have the honor to report that on 19/6/26 at around 1:20 AM, reliable source information was received that one person, Mullah Zakir Hussain, friends, along with his associate, has allegedly being involved in cyber-related fraudulent activities for a considerable period of time. Accordingly, a raid was conducted in his house and substantial incriminating materials connected with cyber-enabled financial crime which were detected and recovered from his possession. After that, he was apprehended and brought to PS. During examination of the apprehended accused Mullah Zakir Hussain, And upon examination of mobile phone used by the accused, multiple Gmail accounts operating under different names and identities were found. The accused failed to provide satisfactory explanation regarding ownership. Further, several bank account, passbook, checkbook, banking documents and accounts credential relating to different banks, including SBI, so-and-so, 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 and others were recovered in his possession. The accused could not furnish any satisfactory explanation regarding operation. During examination of the seized article pertaining to documents pertaining to current.
Yes, I remember the case.
Yes.
What is there in the CV?
Yes, Lordship, on that.
Actually, my lord, the petitioner number one,
Hmm.
he is a my lord, he belongs to, there is a concept nowadays, my lord, in rural areas where there are no banks, my lord. Some persons are interested with and this is called common service center.
Yeah, facilities.
Yes, facilities are there. That is how all these were. And it is not in the allegation in the affair that we have committed any offense. Their only allegation is some incriminating materials were recovered. And my lord, to that, the certificate we have annexed, that is at page 27, my lord.
He has all the licenses and all.
Yes.
That I have seen.
And see, my lord, page 27, Common Service Center, Mullah Zakir Hussain. So, my lord, people can deposit money through him. People can withdraw money through him. So, idea is, my lord, to give the banking services to the people, my lord, where there are no banks. So, in that capacity, he was in possession of all these documents. And, my lord, the other two persons, they were enlarged on bail by the trial court, my lord. The pay order is at page 28 on 3rd of July 2026. So I respectfully pray, my lord, since no overt act has been alleged, my lord, it's absolutely, my lord, nothing to do with this case, my lord. It's not that he has tried to fudge anybody's accounts or he has withdrawn money from somebody. Nothing of this that sort.
Anything has come out in the.
Yes, Lordship. Lordship's order, Lordship has already seen. Now, Lordship will kindly come to the forwarding on that day also. I made this prayer, Lordship, page 22. There, Lordship, apart from the seizure that was made of different checkbooks, savings account, number of accounts were found in his possession, Lordship. Only one thing I'm pointing out, Lordship, apart from the other things, this point number 4 in page 22. Documents relating to a current account maintained in the name of Milan Enterprise were recovered from the possession of the accused. The accused failed to produce any business record, GST registration, trade license, or other supporting documents and could not explain the nature of business activities conducted through the account. So that was there. Now, Lordship, on that day also I have placed that this particular account, Lordship, it was red flagged by the National Cybercrime Reporting Portal. I had flag marked that time because in this account, through this account, different cybercrime related activities took place. Now, Lordship, the IO after verification has received the information. This the details of Milan Enterprise account number so-and-so has checked at Samanyava portal and found total 32 number of cyber complaints against this account. So that is only one aspect, Lordship. Other aspects are being investigated, Lordship. And so far, Lordship, the other co-accused are concerned is the main accused, Lordship, main perpetrator. And Lordship has already observed in the bail rejection order. So at this stage, Lordship, let the investigation continue, Lordship, because if he is released, Lordship, he may tamper with all these evidences, Lordship.
My lord, if my learned friend has concluded, my lord, I would like to point out one thing. My lord, as far as accused number 2 is concerned, my lord, only one mobile phone was recovered, nothing else. Page 26. And my lord, the prosecution must be in a position to link, my lord, the material seized either with some offense which already stood committed or it is likely to be committed.
No, only thing is that only problem in this case is that Milan Enterprise, and Milan Enterprise has been red marked and as far as National Cybercrime Bureau is concerned, there are several accounts, there are several complaints against this Milan enterprise. And this, I mean, so there are further investigation may be required, and he could not explain anything why Milan enterprise account has come to his. I mean,
I'll cooperate with the, I mean, at least, Millard, against petitioner number 2, nothing is there, Millard. Petitioner number 2, only his mobile phone was Millard recovered, nothing else.
petitioner number 2 we can consider, but petitioner number 1 difficult.
At least petitioner number 2
This
case
court
should
is,
be
this,
considered.
this court is very clear. Petitioner number 1, we don't
Millard,
think.
Lordship will not reject at this stage.
Petitioner number.
Let them try to establish, Millard, with Milan, what is my connection?
No, I mean, that is found in your, this thing.
No, my lord,
Yeah,
mere
in your.
possession of some materials may not be enough, my lord. Some overdeck must be.
Yeah, correct. So that's why they need some time to like do the investigation, and it's a huge racket.
So the
It's a huge racket.
consideration for petitioner number 1 may be kept pending, my lord.
The petitioner number 1 will be rejected, and as far as petitioner number 2, we will consider. I'll pass the order.
My lord.
Give the CD.
CD. I'll pass the order.
My lord.
Item 54, 55, and 56.
Finish matters taken at 2 o'clock, my lord. Finish 3 matters taken at 2 o'clock.
Okay.
Obligement.
57.
itu तीन सौ दिन तो मिटे दी गई ना वाला था और रिस्पांस उनके पास में पेंडिंग थे.
Lordship, counsel for the petitioner.
Notice has been served.
Notice served, but Lordship, I have noticed one thing. The informant husband has given his signature, but it should be Bipul Deka, but here signature is of Bipul Kolita, Lordship. That is the thing. Otherwise, notice served.
So notice served, so we'll fix it up on another date.
And Abacus Curie may be appointed, Lordship.
I mean, when it was executed.
It was executed on Lordship 23/07/2026.
So yesterday only. So we'll give you another date. None appears for the accused applicant when the matter was called for. SH Apollo, the learned APP is present. Learned APP submits that service upon respondent number 2 has been completed, and the same was served on 23/7/2026. In view of the aforesaid, let the matter be listed on 6th of August.
6th of August. Lordship, in the case, Lordship, CD has been.
CD received to be
retained.
CD received to be
Obliged.
Or we'll fix it on 4th.
4th of
August. Both the writ petitions are dismissed. The court has come to a finding that the LOA in the instant case it cannot be termed as a concluded contract. Secondly, the precondition mentioned in the NIT are found to be mandatory in nature. So both the writ petitions are dismissed, and you can go ahead with proper allocation.
My lord, I'm grateful.
So the direction has been given.
Lordship, I have a small prayer to make, my lord. In respect of item 57, Lord.
One second. Thank you. Yes.
Lordship, item 57, my lord. The last item was called for before the lunch break, my lord. I could not attend because I was in Lakes, my lord.
So,
My lord, the case diary, I think case diary is available, my lord. And tomorrow there is a admission of the petitioner, my lord, before the ITI course, my lord. So if your lordship is kind enough to, my lord, kindly take up the matter, my lord.
57.
57, my lord. Last item that was called, my lord. 57.
So notice has been served upon respondent number 2, Lordship.
Respondent number 2.
Yes.
But nobody has appeared.
Yes.
So we'll have to hear somebody. We'll have to hear the respondent number 2. Without hearing you, I cannot pass any order.
Amicus curiae has to be
Amicus, my
appointed.
lord.
The amicus has, but this has been, this has been issued, executed only yesterday.
Yes, Lordship.
So you'll have to give some time to them.
Can it be taken about 27, my lord? Tomorrow there is a admission, my lord. I have.
Okay,
already
let it be
annexed
fixed on, then we'll fix it on a 27 also. You'll have to give some time to the respondent number 2. This is something which the right has been given to respond, given
Do admit,
to the
do admit.
informant.
Do
So, we cannot just, the notice has been served yesterday, then we cannot fix the matter today. See, so, somebody has to take, they will have to take some time. They'll have to engage the person.
Lordship is kind enough to engage in amicus, my lord, in that event, my lord.
No. First right is with the informant. Informant is not appearing, then only amicus. We cannot take away the informant's right.
Can it be on Tuesday, my lord? Tuesday or Thursday, my lord?
Okay, let it be fixed on,
Tuesday or Wednesday, my lord.
when is your date, the next date?
Lordship, his admission is tomorrow, my lord, 25th. I have already annexed the document, my lord. Petitioner admission. It is on tomorrow, my lord. The next document has been annexed, my lord.
Admission.
ITI course, my lord. 19-year-old boy, my lord.
And he is behind the bars.
Lordship, 48 days as on today, my lord.
So tomorrow, then how it will be done?
Lordship is already tomorrow his admission is due, my lord. That is the difficulty, my lord. Can I make an interim prayer, my lord, in that eventuality, my lord? Because 1 year will be gone, my lord. If he is not allowed to be
Admission where?
ITI course, my lord. ITI course, my lord, that is the
Only, only 1 day for counseling.
Gateway Academy, my lord. The letter has been received, my lord. And it has been, we approve you to.
Gateway is a private university, right?
Lordship.
So if you file an application for another date, you file an application. It's a private university. I don't think private universities are so adamant on a particular date, huh?
Gateway Bayada Sariali.
Correct. You file an application that you can take the admission later on also. We'll give a date, but today it won't be possible. We'll have to hear. This is a crime which is not in the nature that. You come up with an instruction when it can be done. You tell the parents when if they can find out another date.
Next date, my lord, next week, my lord. On Tuesday or Thursday, my lord, if possible, my lord. Up to your lordship. Because already 25th, tomorrow it will be gone.
Okay, let the matter be fixed on 28, then to 28. 28.
Lordship.
Okay.
Problem, lordship.
CDB retain, Lordship.
CD retain.
I have 24. Hey.
Every in the GDN also, everything was completed before under 5:20 PM, Lordship. So that was the non-authority letter was not issued or to issued, Lordship. That there is no authority letter in person to that, Lordship. Because before sunset, she was taken to the police station. But arrest of time was in the 47 notice also, it was reflected in the note that at 5:20 p.m. he was taken to the police station, but the date and arrest of time was shown as 10 p.m. 11/3/26 in the bottom part, Lordship. I have flagged but a GD entry also, Lordship. 47 and 48 notice also, it was stated in the note.
GD entry is 21:51 hours. So in the night, they have made the GD entry.
But another GD entry was there, Lordship. At 5 days, they were informed by the authority, Lordship, at 5:20 p.m. they have a police station. Everything they have prepared before 10 p.m. That's why they have written the arresting time is 10 p.m.
No, I mean, the GD entry is all made sometime around 9 o'clock at night.
Before 10. That's why the
Before
arresting-
10.
Entry was made, but they have
9 Even then, Lordship, it's after sunset.
So nothing is available that she has been arrested before the sunset. No material.
everywhere they have inserted that time only 10 p.m. And seizure time is not 3:10 p.m. Search and seizure. At 2:20. All the proceedings they have followed before 5:20 p.m. Lordship. But only thing is that, Lordship, they have written it date and arresting time is 10 p.m. They have detained the person for receiving the information, and search and seizure was made on 3:10 p.m. at the time of 3:10 p.m. Lordship.
Search and seizure when?
3:10 p.m.
3:10
Lordship.
in the afternoon, that means.
Afternoon.
So, yeah, Mr. Chaudhary, you have been detained earlier to that
Yes.
during the daytime.
Lordship, one more.
And custody detention arrest, all have been discussed by the Supreme Court. Now thing is that in certain cases, what happens is that arrest memo is shown to be at some other time. And then you argue that, no, I have been detained long before, and 24 hours is, so whether you can do that thing.
Yes,
Here it has been detained. Mr. Mahajan will know.
when the physical movement is restricted, at the time is shown is as
Yes, Mr. Mahajan, the person is detained. Search has been made. And he has been detained in the afternoon. Then process was completed. But only the arrest memo shows that like, the person is arrested in the night. So what is to be taken?
There is a full time or after. When my lord arrest has been shown to have been made at night. When there are 2 times of arrestment, it can also my lord, it can possibly my lord. The accused will serve him. Even that.
But
Detained at night, maybe that benefit possibly you know.
One more thing, Lordship, can you produce Lordship section 42 subsection 5 Lordship?
yeah, that is clear. That is clear.
there.
That
And
is-
moreover, Lordship, kindly come to the section 42 of the Lordship, NDPS Act. Lordship. There, Lordship, the arrest has to be made by the search and seizure has to be made by an inspector above the constable rank, Lordship. Here the group, Lordship, here the police party belongs to one woman police constable, Lordship. The search and seizure has to be made by above the constable rank. Lordship. That is.
No, there are that he is one of the person. The other persons are also there.
But the arrest has to be made by the lady, Lordship. She cannot be arrested by the male person, Lordship. Here the arrest has been made by the male person, Lord. Notice shows, Lord.
And 40:1 permission was taken, Lordship. That GD entry was there, Lordship. No, authority letter was also there.
Permission for
42 search and seizure, Lordship.
search and seizure is fine. We have already passed an order. This court has passed an order. You have that order.
No, Lordship.
No.
That,
They don't do proper research.
Lordship, that last day I have regarding Lordship.
No, I mean
21 and Lordship
Yeah,
regarding
40,
62 that I have placed on the last occasion. Lordship.
43.5, we have already passed some orders. Okay, we'll look into the things in little bit details and pass the order.
I will also tag the GD entry in detail, Lordship. All the GD entries.
How does it help?
At the time and authority letter also.
Hmm?
Time and the when they have.
But you have written in the arrest memo this. I mean, your police people are not properly trained.
I did.
We'll pass the order.
54 to 56.
Dear Lordship may possibly my Lordship has asked us to find out as to whether there is a statutory provision or any article 141 or 142 authority, my lord, as to whether when there is an encounter, my lord, or my lord, one-way firing by police, my lord, if somebody is injured, my lord, because of injury is taken to hospital in that situation, my lord, and not reported to court. And thereafter, after recovery, he is being produced in court, my lord. Exactly same scenario here, my lord. There is no statutory provision as such, my lord. My lord,
The statutory provision is only this 24 hours that, that article 22.
Exactly, my lord, that
Hmm.
will hold water, my lord. Secondly, my lord, with all respect, my lord, here what has happened, my lord, of course, this is, my lord, convention, my lord, as I have seen, my lord. I bring some certificate copies also, my lord. The normal procedure is, my lord, during alpha days, my lord, when a young lawyers, my lord, many accused persons were not produced because gunshot injury, my lord. Then the procedure is, it is not visualized in the code at that point of time. Now BNS says, my lord, that a forwarding report goes that the accused was arrested. Here, little bit different scenario, my lord. The accused has been arrested, but has not been produced in court. Upon recovery, he would be produced. At least intimation is given to the court. Under 167 at that point of time, now 187, my lord.
187 now.
Earlier 167.
Now 187.
Now 187, my lord. Because, can you one line more? I'm sorry, my lord, one line more, my lord. Because on the date of occurrence, when the firing incident took place, exactly on those materials, no further materials, my lord. Demand of money, firing, my lord, police say, my lord, exchange of fire, whatever be it, my lord. That, my lord, firing took place, my lord. So materials were available on day one when he was admitted to hospital. They cannot say that without posting guards, my lord. Have I made, he was already in detention, my lord. He could not have been kept in hospital because on the same materials upon recovery, the forwarding report exactly on the same story of 25th. And subsequently, my lord, upon being produced, no new materials. Have I made my position clear?
That's clear. That's the same
My lord,
materials.
my lordship knows more than I'm sorry, my lord. But I'm saying Niranjan Singh would be in totality, it would be applicable. Secondly, my lord, otherwise also we may get benefit because the reason, my lord, in DK Bosu, it is now also not codified, my lord. If there are two times of arrest, because the magistrate wrote in one order, my lord, there is no formal arrest or informal arrest as per Niranjan Singh, my lord. The magistrate, luckily or unluckily, my lord, luckily for me, unluckily for the state, my lord, with all respect, magistrate recorded that formally he was arrested in one regarding
So
one.
there is no formal or arrest or informal
So, my
arrest.
lord, meaning thereby formal arrest means, my lord, on the date of production, meaning thereby there was an informal arrest earlier. So automatically, my lord, 24 hours has been violated, no two ways about it. It
So
cannot
without any order of the magistrate, you cannot.
be
you just
remand,
cannot.
my lord. Remand, my lord. At least intimation has to be given. Can I just place, my lord, not, my lord,
Yes, please.
my lord, two orders we have found out, my lord. In such a situation, what the police does. Police exactly under earlier 167, now 187, my lord. Without forwarding the accused, a letter is forwarding report is given that upon recovery he would be produced. And here kindly see, my lord, on day one, the non-injured person was produced. There are three non-injured person was produced. So, my lord, the task of the police was much easier. They should have added one line in that forwarding report, two he could not produce. That, my lord, and that, my lord, Bhagalpur blinding case, my lord, they are of course in judicial custody. Without production, they were sent to jail, my lord. Blinded prisoners. So exactly same scenario in a reverse manner, my lord. Here, my lord, when somebody is in hospital, on the same materials, upon recovery, you arrest him. No new materials, my lord. They cannot now plead, with all respect, my lord, that on day one, when he was injured and admitted to hospital, there was no material against him.
No, I mean this when he was injured, he was taken to the hospital by police only.
By police, exactly, has to be, my lord.
Police only.
Police encounter.
And he was there in the hospital. And whatever medical, this facility was required, it was given. And then on his recovery, he was produced.
So 24 hour, that article 22 and violate. And secondly, my lord, Apex Court one authority, my lord, with all respect, my lord, in these encounter cases, there has to be an inquiry, my lord. That is also independent inquiry, my lord, by an officer above the rank of the officer who participated in that, my lord, encounter or whatever be it, my lord. Even that has not been followed.
Okay, that's a separate matter.
Separate matter. Well, I'm not on that. Sorry.
So this is 20.
There is another one. This is recent, my lord, with all respect, my lord.
This Krishna Mohan Nath, what is this?
This is
This order dated 20/2/2026. or this is not order, this is inspector.
This is intimation, my lord. Madhav Das, my lord. Intimation regarding arrest and medical treatment. This is the procedure, my lord. They should have shown him, they have not shown, my lord, they should have arrested him on the date of his admission by sending this sort of a report to the, my lord, forwarding report to the magistrate without his physical production, my lord. My lord, reading between the
No, this court's, this thing is, the anxiety is concerned. See, there is a specific provision saying that without remand or the order, you cannot keep anybody beyond
Well,
24 hours, correct?
here that has been violated.
That is violated, but whether an intimation will suffice, that's what I'm thinking about.
My lord,
Why, if an intimation
They-
has been given and on the basis of such intimation, some order has been passed, then it's a different thing. But if only intimation has been given, but
No.
there is no order of any remand, then whether,
my lord, illegal.
Huh?
Illegal. My lord, here what has happened?
so only with the intimation whether
No,
it will
no,
do.
no, my lord. After the intimation, there is a consequent, my lord, with all respect, my magisterial order, my lord.
So in this case, it was there,
Every case it would be there. Next page it is.
or it has been given, passed an order.
Yes.
Okay, here, okay, the order is passed here.
Here, my lord, only the thing, my lord, information was not given.
Hmm.
Hence, my lord,
There was no order.
there was no order. But, my lord, upon being produced,
And that's
I should not say, my lord, the learned, I've got nothing against the learned magistrate, my lord. Only, my lord, actually, that exactly Bhagalpur blinding case, my lord, they are in judicial custody. The magistrates were holder. I'm not saying that they should be holder here, but they should have at least incurred when the occurrence took place. And if these days where they were without a formal order of remand. But that was not carried out, my lord. Because those days, my lord, in hospital, there is no, my lord, medical custody, my lord, either police custody or judicial custody. They would have been in either custody, my lord. To that, a remand order must have been. Because no intimation was there, hence the magistrate, he didn't pass any order. But upon being produced, it was the bounden duty of the magistrate to ask him, when did you obtain those injuries? Because physically produced, and all, my lord, grievous injuries, my lord, gunshot injury. Criminals may be, my lord, but in accordance with law, my lord. So that, my lord, the magistrate may have failed, my lord. I have got nothing to do with it, my lord. That only they were in custody.
And in your case, while he was produced later on,
My lord,
then was there any application for bail?
that we do not know, my lord.
Because that is important, because if you have not pressed for a bail, then what order magistrate is going to pass?
No, my lord. When he is produced by the forwarding report.
Then if you do not seek for a bail, then he will be remanded.
No, my lord. I may be wrong, my lord. Kindly visualize the situation. If there is no bail application also, my lord, the forwarding report will state, my lord, that there was an encounter on so and so date. Produced some days later.
No, understood. No, that is
Then the
understood.
magistrate should have incurred and found out.
No,
That is the given situation.
No,
my lord.
that is understood. Now visualize the situation. Now, in your case only,
My lord.
now after his recovery, he was taken to the magistrate.
Exactly. The forwarding report will
Forward
state that.
report, yes, the forwarding report, that intimation is there or not there, I don't know, but we'll have to look into it.
My lord, with all respect, my lord, that forwarding report after recovery by which he is produced, they must write one thing. They must, means that
They must intimate that he was injured, then he was taken to the
Exactly.
hospital
That
and
is
then.
sufficient, my lord, for the magistrate. To take cognizance, my lord. There may not be a bail application, my lord. It is not that I am to agitate. Law is as such, my lord, because it is the duty of the magistrate to ask, my lord. Upon being produced by police, that all these days where you were.
And he was delayed in producing, then he should have been.
Hold up. Police should have been hold up, ministerial duty, my lord. Because of the non-taking cognizance of this, my lord, by the learned magistrate. I have got nothing against what I am saying, factual metrics, my lord. then what will happen, my lord? We have to come up before your lordships and place this, my lord. Whether he gets bail, doesn't, that's a different matter altogether, my lord. But my lord, first of all, my lord, the constitutional mandate. Thereafter, the statutory mandate. Violation of both, my lord. Otherwise, police, whatever atrocities, maybe, may not be, my lord, that I do not know. But some, my lord, with rudiment of, my lord, with all respect, my lord, impartiality and everything has to be there. Palpably read, my lord, read large on the face of the record, my lord.
Okay, for this person, that is the case.
My lord. Second one, my lord, he was also produced after 24 hours, but he was there in hospital for.
So Jitumoni Bora Gogoi is the main person who was injured.
Two persons were injured.
And Ritu Gogoi.
In Ritu Gogoi, formal arrest words are there because different dates of production, my lord. Because different dates of
And
recovery.
both got injured, both were hospitalized
Yes,
initially.
my lord. One for a limited duration, 2 days, 3 days. The other for a longer duration, 1 month or subsequent, my lord. Ritu Gogoi is more than 1 month.
And what about this Kipro Gogoi?
Kipro Gogoi produced within time.
Kipro Gogoi is not injured because no gun.
He was produced in India.
Due time. Can you see, my lord, with that production, yes, their formal duty was to give another intimation to the court that these two have been booked together. Otherwise, my lord, how out of 3 criminals, one would be produced, 2 would be in hospital without a formal order of remand? That cannot happen, my lord. Luckily, the situation is as such, my lord.
Yes, Mr. Sharma, you have anything?
That is the thing, my lord. One only Kipro Gogoi, my lord, is produced within time, my lord. And other 2 persons, my lord, they were produced after their recovery. And my lord, regarding death, my lord, there is no intimation to the court, man. There are 187, my lord, that should have been.
Okay, then we'll have to allow them to go on bail.
Yes, but my lord, regarding my lord Kipro Gogoi, but sufficient materials is there, my lord. And my lord, that is also, my lord, he is also produced within time, my lord. At 25, my lord, he was arrested, my lord.
Correct.
And then, my lord, on 26, at 2, my lord, he was produced before the.
Okay,
Regarding him,
as far as Kipro Gogoi, we'll look into the CD and we'll.
My lord.
And other 2 things like admittedly they are produced beyond 24 hours.
Yeah.
Kipro Gogoi has materials against him, my lord. On merit, my lord. No violation, my lord.
Yes.
Okay, we'll pass the orders.
Highly obliged.
On this item was 41. Application. 483 application list. The second time application list. As on that 81 days beyond the available.
Yes, Sarsit subject discuss.
You go and appear. Heard Mr. B. Islam, learned counsel for the accused applicant, also heard Mr. D.P. Goswami, learned AP for the state, is an application number 483 of BNSS 2023, paying for granting bail to the accused applicant in connection with Boko PS case number 106/2026 under section 64 in bracket 1 of BNS 2023. Case there in the instant case has been received. Then the learned counsel, case there received.
Sarsit,
Yeah. Then the charge sheet in the learned APP submits that charge sheet in the instant case has already been submitted by charge sheet number
165/26 dated 36/26.
26. In view of the aforesaid submission, the learned counsel appearing for the accused applicant submits that liberty should be given to him to approach the jurisdictional court for appropriate relief. In view of the aforesaid, the instant bail application is disposed of with liberty to the accused applicant to approach the jurisdictional court for appropriate relief.
43.
How did you have not received the case diary?
Well, in this case,
CD has come.
Did not receive, Lordship.
I'm on interim, my lord. On that, no problem. But this case is pending since September 25.
Earlier
And
CD
for-
was there, it was sent back for
Yes,
updation.
for updated CD, I think 15 numbers of dates.
Why it is taking so much of time?
Lordship can my lord dispose of this case, my lord, nobody.
We have communicated many times, 6/6/20.
Communication will not do, Mr. DP Goswami. Your police officers are so arrogant, adamant, and what? Some give me some languages, some words. We'll make it confirm. Heard Mr. A.K. Azad, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned APP for the state. It is an application under section 482 of BNSS 2023, freeing from pre-arrest bail to the accused applicant in connection with above PS case number 57/2025 under section 318 in bracket 4 stroke 316 bracket 2 stroke 303 bracket 2 BNS 2023 read with section 66 in bracket C stroke 66 in bracket D of the IT Act 2000. By order with the 16/10/2025 of a coordinate bench of this court, the accused applicant was granted interim pre-arrest bail in the instant, interim pre-arrest bail full stop. From the records, it is seen that though case diary was called for, interim order was passed on perusal of the case diary or not? Nothing is there.
Case diary, I think, my lord.
Hmm?
On perusal of case diary, then it is.
The nothing has been written in the order.
It was passed on 16/10/25. Your statement was not there, I think.
No, case diary is not somewhere, not given. I mean, prayer was made for bringing updated case diary. Okay, there was received not up to date.
Yes. The updated-
Right, though an updated case diary was called for in the instant case, but same was not produced, not produced even after a lapse of almost 9 months. A lapse of almost 9 months. As many as 15 occasions, time was sought for production of the updated case diary. Taking into account the aforesaid lapse on the part of the prosecution, this court is of the considered opinion that the interim pre-arrest bail granted to the accused applicant wide order dated 16/10/2025 should be made absolute. Accordingly, the instant AV application is disposed of by making the interim pre-arrest bail dated 16/10/2025 absolute in the same terms and conditions as mentioned therein.
Sorry, Prof, we have not received the case diary. Please, Madam, in time.
Case diary not received. Let the matter be fixed on 4th July. Interim order so passed earlier shall continue till the next date of list.
Another item, item 58, my senior counsel is no come to April due to water closing, but kindly fixed to Monday or Tuesday, Item 58.
Seeking adjournment for today, Lordship.
CD received?
CD received.
Okay, on the prayer of the learned 58 learned council appearing for the accused applicant. The matter is adjourned and to be listed on 5th August. CD to be retained.
Obliged.
46. Letters leading to child marriage.
Service report is not yet
Hmm?
completed.
Issue number 1 is my lord, husband. Issue number 2 is the father of the boy, and issue number 3 is the father of the victim. FIR is placed, my lord, 8. Only husband's name is mentioned in the FIR, my lord. The 2 accused, issue number, my lord, not mentioned in the FIR.
Notice was issued to respond number 2.
My lord.
Interim bill was granted to all.
No, my lord. Only petition number 3, my lord.
Yes, Mr. Goswami, what is there?
Victim statement. In 180 statement, they have, she has stated, yes, they have some relationship after she eloped with him, Lordship. After he got pregnant, and the child was born, Lordship. That is statement. Thereafter, Lordship.
This is an application under section 482 of BNSS 2023, praying for granting PRS bail to the accused applicants in connection with Dolgaon PS case number 58/2026, registered under sections 115 in bracket 2 stroke 332 bracket B small b stroke 351 bracket 2 stroke 64 bracket 2 small m bracket m of BNS 2023, read with section 6 of the POCSO Act. Wide and order dated 19/6/2026, a coordinate bench of this court had granted interim PRS bail to the accused applicant number 228. Full stop. The allegations in the FIR.
Page number 24, Your Lordship. Second para.
The allegations in the FIR dated 13/4/2026 is the commission of rape on the complainant's minor daughter by the accused applicant number 1 after promising marriage. Full stop. Full stop. It was alleged that in spite of promise of marriage on several occasions, the accused applicant, after committing the rape, refused to marry the victim girl. Full stop. The CD in the instant case has been received. Mr. Your name?
M. Ahmed.
Mr. M. Ahmed, the Learned Counsel, appeared for the what is your submission?
My submission would be, Lordship, only anticipatory bail should not be granted to one.
So and so opposes the prayer of bail of the accused applicant. CD in the instant case has been received, and the same is perused, and after taking into account the materials available in the CD, this court is not inclined to grant any pre-arrest bail to the accused applicant number 1 at this stage. Full stop. However, as far as accused applicant number 2 to 8 are concerned, since they have already, you have all appeared.
Yes, Your
They have already appeared before the investigating officer and have been cooperating with the investigation. The interim pre-arrest bail order dated 19/6/2026 is made absolute. In terms of the aforesaid direction, the instant AB application is disposed of.
Deep, Your
I am on interim, my lord. CD was
It
called
is
for.
CD not received, Lordship. It is on interim.
I appeared before the IO on 17, Lordship.
Let him go. This is none of a small fight.
My lord, 61 is of same affair, my lord.
Hmm?
Item number 61 is also same affair, my lord. That was not in on
Hmm?
interim, my lord. 61, my lord.
See, 61 also interim is there.
My lord,
No interim.
No, this one, I mean, this person is not directly involved.
Yes, my lord. I had already appeared before the IO on 17 July. Lord.
Other one will not consider now, but this one will making absolute. This is he's not directly involved.
Yes, lord. He's not in.
Heard Mr.
H. Rahman, lord.
H. Rahman, the learned counsel appearing for the accused applicant, also heard Mr. D.P. Goswami, learned AP for the state. This is an application filed under section 482 of BNSS 2023, bring for granting PRS bail to the accused applicant in connection with Nazira PS case number 25/2026 under sections 118(2) stroke 109 bracket 1 stroke 3 bracket 5 of BNS 2023. The accused applicant was granted interim protection by order 13/7/2026 by this court. Full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid order 13/7/2026, the accused applicant has already appeared before the IO and got his statements recorded. He further submits that the accused applicant will fully cooperate with the investigation. Taking into account the aforesaid, the instant AV application is disposed of by making the interim pre-arrest bail order dated 13/7/2026 absolute. In terms of the accused direction, the instant AV application is disposed of. In number, and this one, 61, you write, CD not received, let the matter be listed on 5th of July. 5th of August. 5th August.
Here your CD was called for.
I'll get up at 3 o'clock for 5 minutes, 5 or 2 minutes, maybe 2 or 3 minutes, 5 minutes, whatever. Just so I'm just intimating. Mr. Kamar is also sitting here. Okay, yes.
This statement has been recorded, your lordship. FIR, your lordship will get it at page 14. The vernacular, your lordship. The translated
Yes.
is page 10, your lordship.
Page 10.
I beg to inform you that we have come to know that there has been some immoral activities being carried on in Rajmahal Hotel situated Gauhati, Nagar. It is with much sadness that we beg to inform you today that Sunday, so and so at around 11 o'clock, we have gathered with the local people and caught red-handed boys and girls in immoral activities in room number 101, 102, 102.
Yes, what is there, Mr.?
Yes, he is the owner of the hotel and sufficient materials against the hotel lordship and some things were recovered from the hotel, and the hotel is Rajmahal. The hotel is occupied by girls and boys in compromising and inappropriate condition. Upon verification of the hotel's guest register, it was found that room number 102 had not been allotted or booked in the name of any male occupant, despite a male person being found present therein, establishing deliberate concealment and falsification of mandatory guest record lordship. And in the investigation lordship, sufficient incriminating materials. I got a statement of the recovered lady. 3 ladies were recovered from the hotel room. Now, your lordship will kindly see, your lordship. This is not a case of trafficking, your lordship. They want to give a color of trafficking, your lordship, but its trafficking is not there, your lordship. Through one adult or 2 adult person come to my hotel, your lordship. First of all, I don't look after day-to-day activities. This is by the manager admitted. Now he was arrested. Now your lordship will kindly see that some adult people come.
The manager is arrested. He's behind the bar.
Yes, he is behind the bar. Now your lordship, some people come to the hotel, your lordship, book a hotel, whether it is a ladies or a gents, your lordship. If it is adult, it may be a immoral, your lordship. It cannot be a criminal offense, your lordship. And your lordship, trafficking has a certain meaning.
But they say boys and girls.
Boys, no, your lordship, these are all adults, your lordship. There is nothing, your lordship. I have annexed page 16. Your lordship, this is ground of arrest in respect of the manager, your lordship. What is there? Nowhere says that these are girls and boys, your lordship, who have not crossed the adult age, your lordship. That is not the case, your lordship. And ultimately, your lordship, if someone comes, book a hotel who is not a minor, your lordship,
and what they do within the four corner of a room, your lordship, how can I be responsible for that, your lordship? It may be morally, it may be not acceptable to people, your lordship, but it cannot be a criminal offense, your lordship. And just to make it a non-bailable offense, they have brought in, your lordship, trafficking. The definition itself of the trafficking as given in the BNS, your lordship, is very clear, your lordship. It will not come under trafficking, your lordship.
So which is stated that the owner and along with his manager lordship taken some money and some school college students given room rent for 1 hour, 2 hours for the local witnesses complain against this and received from information from the local witnesses lordship.
If they are
Have raided the
minor,
hotel.
lordship, in that event, your lordship.
No, otherwise also, Mr. Bothak, you
Lordship.
cannot allow these things to go on. I mean, see, if you are saying that like whatever they do inside the hotel or hotel room, you
No,
are
your
not
lordship.
aware, and I mean that
No,
statement
that-
cannot be taken.
No, your lordship, what has fallen from your lordship, not absolutely. Morally, your lordship, yes, your lordship. That should not happen, your lordship. That's I am, but your lordship, whether custodial interrogation in this case at that.
No, I mean, the investigation is still going on. We
Yes,
don't
but-
know. That's the allegation is that you take money for 1 hour and give the room to
No,
them.
your lordship.
For
will-
what you give the room
No, your
to them for 1 hour?
Your lordship will kindly see, your lordship, what role I have, your lordship. And your
No,
lordship.
your role is
No,
that you
ma-
are
your
the owner of the
No,
hotel.
your lordship will kindly call for at least my statement, your lordship. I have given my statement, your lordship. It is recorded.
Your statement you will deny it.
Lordship, that is what, your lordship, whether custodial interrogation at all is required. It is morally not acceptable, your lordship, that I understand, your lordship. What has fallen from your lordship now? My humble submission, probably, your lordship, his custodial detention is not required in this case, your lordship. And had it been a case of minors, your lordship, yes, then your lordship, I would not have come even in a anticipatory bail application, your lordship. Only thing, your lordship, I have cooperated with the investigation, your lordship, and my statement has been recorded, your lordship, thoroughly interrogated, your lordship.
Mr. Goswami, any special allegations against him, specific?
Specific only the periods of time it was going on lordship. So he was well aware of the fact that yes, my hotel is used for that purpose lordship. Without the consent of him or non-consent of him, because he is the owner of the hotel. What is going on in his hotel premises, he was well aware of the fact lordship. Now simply he is simply denying it. But other local witnesses and other persons and the victim ladies also who has recovered from the hotel.
Give me the CD. The statements of other people, let me see.
I have been the last person to, your lordship, defend such activities, your lordship, but on the point, your lordship.
No, that
whether-
is not doubted, Mr. Bothakar. But that is not doubted.
Lordship,
I
what-
mean, we are not doubting that, but
Lordship,
only
your
thing is
lordship,
that.
whether criminality is there or not, and your lordship, whether, your lordship,
See,
the case.
Mr. Bothakar,
Lordship.
many things happen without our knowledge.
Lordship.
Maybe without your knowledge also.
Lordship.
And many
Custodial
things.
detention is required or not, your lordship, that is my point, your lordship. And in fact, your lordship, the non.
You see, one thing, Mr. Bothakar, see, we all know, Mr. Kamar is also their senior counsel. See, we all know that in many of them, in most of the cases, custodial detention may not be required.
Lordship.
But what about the society? What about the deterrent? I mean, if somebody who has committed a heinous crime,
Lordship.
and if you just leave him go after 1 day, then what will be the deterrent factor?
Lordship.
That has to be also seen.
Lordship.
I mean, that's perfectly fine. If trial is pending, so I mean, what's the point of keeping him inside the custody? That's there.
Lordship.
But there are other factors also.
Lordship, that is there, your lordship. I don't deny that, your lordship, but. And his hotel has also been sealed, your lordship, in the meanwhile.
This is Rajmahal, this is Paltan
No,
Bazaar.
your lordship, it is in Dhuburi.
Or it is Dhuburi.
Gwalpara, your lordship. You will abide by any condition imposed by this honorable court, Your Lords. If your Lordship comes to page 17, Your Lordship.
Just a minute.
Lords. And in fact, Your Lordship, I myself has telephoned the police, Your Lordship. Thereafter, police came.
You must have been very smart over.
That is. In view of the fact that your statement.
This interim was granted after, no, CD was not there. at the time,
Not,
right?
CD was not there.
It was not
On the
there.
very first day interim was granted.
Only the manager was said, later on he was the owner of the hotel, considering the fact.
Okay, heard Mr. S. Botaku, the learned senior counsel, assisted by Mr. So-and-so, learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned AP for the state. This is an application under section 482 of BNSS, praying for granting bail to the accused applicant in connection with Goalpara PS case number 113/2026 under section 61 in bracket 2 stroke 143 bracket 3 stroke 114 bracket 2 of BNS graduate section 3 stroke 4 of Immoral Traffic Prevention Act 1956. A quoted bench of this court, then you write, the allegations made in the FIR, allegations made in the FIR dated 29/6/2026 that the accused applicant is the owner of the hotel Rajmahal, wherein on the complaint of the public, a raid was conducted and found several boys and girls engaging in immoral activities in certain room numbers, in certain rooms of the hotel. A coordinate bench of this court, White Order Act 77/2026, has granted interim protection to the accused applicant, full stop. The learned Mr. S. Botaku, the learned senior counsel appearing for the accused applicant, submits that the accused applicant is the owner of the hotel and he is not, he does not look into the day-to-day affairs of the hotel. He further submits that the manager of the concerned hotel has already been arrested and he is behind the bars. He submits that since he has been given the interim protection, he has already appeared before the investigating officer and got his statements recorded. He submits that in view of the aforesaid, his further custodial detention may not be required in the instant case. CD in the instant case has been received and the same is perused. The learned APP, Mr. D.P. Goswami, opposes the prayer of bail of the accused applicant in the instant case. This court has perused the case diary and after hearing the counsel appearing for the respective parties, is of the considered opinion that the interim protection dated 7/7/2026 should be made absolute. Accordingly, the instant AB application is disposed of making the interim pre-arrest bail order dated 7/7/2026 absolute. CD to be returned. We'll just come back in 5 minutes.
Was granted interim bail, Lordship. Thereafter, I had appeared before the IO, Lordship. Co-accused already granted bail, Lordship.
on 22, Lordship.
Yes,
He was appeared in after getting interim lordship, but against him lordship sufficient materials are there in the CD because the committed that offense lordship, the CDI analysis, he was present and the interconnected mobile phone state analysis was here lordship. He was present at the time of occurrence. He was along with them to committing the crime lordship. And the co-accused statements and other persons statements who saw them that he was present at the time of incident at the all they are loitering in here and there lordship. It's an organized crime and he was an associate and part of that organized crime lordship.
where is the FIR?
Lordship, FIR is at page 13, Lordship. And XRA.
Let us see the CD.
Yes, lordship.
Heard Mr. P. Bodley, the learned counsel appearing for the accused applicant, also heard DP Goswami, learned AP for the state. There is an application under section 482 of BNSS 2023, praying for granting PRS bill to the accused applicant in connection with Bokolia PS case number 4/2026, registered under section 61 in bracket 2, stroke 331 bracket 4, stroke 351 bracket 3, stroke 311, stroke 31009 of BNS 2023, read with section 25(1) bracket small a, stroke 27 bracket 2 of the Arms Act 1959. Allegations as narrated in the FIR dated 21/2/1026 filed submitted before the officer in charge of Bokolia PS police station that the some miscreants came to the house of the informant and demanded rupees 20 crore and 20 crore by displaying a pistol and firing one shot. It was alleged that they opened one wooden armory present in the inside the bedroom and looted 40,000 rupees. And thereafter, when, thereafter, after hearing the presence of villagers taking advantage of the darkness, the miscreants fled away. Full stop. On receipt of the FIR, please register Bakulia PS case number 4/2026 under the aforementioned sections. Learn white order dated 26/6/2026, a coordinate bench of this court has granted interim pre-arrest bail to the accused applicant, full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid direction, the accused applicant has already appeared before the investigating officer and fully cooperating with the investigation. Therefore, he submits that the custodial retention of the accused applicant in the instant case may not be required. The CD in the instant case has been received and the same is perused. The learned APP, on the other hand, opposes the bail for fear of bail of the accused applicant. Taking into account the materials available in the CD, this court is to consider the opinion that the interim pre-arrest bail granted on 26/6/2026 should be made absolute. Accordingly, the interim pre-arrest bail order dated 26/6/2026 is made absolute in the same terms and conditions mentioned therein. Accordingly, the instant bail application, the application is disposed of as allowed.
Obliged. 60 Lakshmi, we have received the case diary. PM report is not available in the case diary. But the inquest report date cannot be ascertained. What is the original cause of death? The PM report is required.
Cause of death is not certain.
That's not a certain without the PM report. Allegation is planned murder, but section attributed here 108. Again, going to this.
Was there any poison? Nothing.
That is not reported, not here, Lordship. So whether is poison is imposed or not, that is cannot be ascertained now. He was recovered from a phone, Lordship, by drowning. So viscera was taken at Sanford FSL.
PM may be confirmed, my lord. Postmortem report may be PM.
Is this?
Lord, kindly fix it on order that my senior will be appearing in this.
Hmm?
My senior will be appeared in this case, my lord. Fix
She
it on
will
order.
be appearing. Okay, we'll give them some, let his senior come. On the prayer of the learned counsel appearing for the accused applicant, let the material fixed on 4th July,
Within the city.
CD to be retained.
Admission.
Yeah, please, Your Honor. The present application, it pertains to matrimonial dispute, Lordship. And also, in pursuant to this matter, both the parties have went to do mediation, but that has been failed, Lordship. So, if one chance is given, Lordship, there might be a scope of settlement, Lordship.
Mediation is failed, you are saying. On the other hand, you are saying
No,
there is a.
No,
Since first time appearing.
I have been newly engaged by the council, so my learned, we both have given a proposal. Both the parties are ready to talk for once.
Just one more chance. If it doesn't succeed, Lordship, then we'll proceed.
And a short date may be fixed for hearing
Your
of
name?
this matter.
Arya Singh, Lordship.
Heard Mr. Arya Singh, the learned counsel appearing for the petitioner, also heard Ms.
Miss P. Chaudhary.
Huh?
P. Chaudhary.
P. Chaudhary, for the respondent.
Number 2.
Respondent number 2. Ms. P. Chaudhary submits that she has been newly engaged in the incident case and she has been engaged in the incident case. Full stop. The council appearing for the respective parties submit that though the mediation has been failed, there are still some talks are going on for settlement of the matrimonial dispute. Full stop. Accordingly, they pray for the accordingly prayer is made for adjournment of the matter for 2 weeks. Let the matter be listed after 2 weeks.
Lordship, a date.
Prayer is allowed, let the matter be listed after 2 weeks. Entering of the superstar years and continuing the next step of listing.
Your Lordship, a date can be fixed for
2
hearing.
weeks, 2 weeks.
2 weeks.
किसे सबने receive?
The state.
Huh?
I'm referring for the state.
Okay, SH Bora and a P for the state. TCR is scan copy only.
Can for the state.
To be retained.
17.
Even 12th August. 12th August.
2 weeks have been given to you. sufficient time.
Kindly, if a
No
date.
date, no date. Okay, 12 August. Later matter listed after 12 August, on 12 August.
In this case, we have come for passing of an FIR, man. FIR in the sense, I was a recently SP client at that point of time, and once he Pintu Pathak, my lord, he was the director of vigilance, my lord, DSP, and anti-corruption laws in FIR, man. And
Passing of the FIR.
yes, ma'am. There are two aspects in the FIR, ma'am.
Hmm?
There are two aspects in the FIR.
Hmm.
One aspect is relating to section 7 of the DC Act, my lord, regarding demand of money or rupees 50,000, my lord, demand of 2 lakhs and acceptance of 50,000. Now, because the witnesses, my lord, I have given an affidavit, they have never made any amount to me.
Hmm?
They have sworn in affidavit
Hmm.
that no amount was paid to me, man. And during investigation, they were never examined as on today, man. On the basis of report submitted by SP, it was reflected in that FIR, man. Now, no transaction, nothing, man. I don't know whether in the city, whether they were examined or not by those two witnesses.
They have been examined.
No, my lord. Because it is of FIR of 2025, man, month of September.
You haven't gone through the CD.
My lord,
Sharma.
my lord.
CD is supposed to be read before the matter is reached
My lord.
on board. If you need
My
some
lord,
time, you
my
take
lord.
some time, but don't appear unprepared. It takes time. I mean, court has to do lot many things. Judgments to be delivered, order to be passed, proofreading has to be done. Correct. So it takes time. You want some other date? We read the CDs, we find, at least you find out whether statements have been recorded.
Statement are not.
Or statements have been.
Statements are not there, yes. Statement are not here.
Statements are not, the statements.
In the investigating stage.
You get the statements, you bring the statements.
They never record, no attempt made to record the statement. The lordship more than a year has gone.
So how the investigation is going on?
Keep the matter pending,
You
man.
should be immediately receiving the CD, you find out these things and like, tell these people.
Otherwise they drop the case, there is no case is made out. Unless they have to make the pending, matter pending, man.
Otherwise, my lord, CCTV footage was there, my lord. Regarding the acceptance, my lord, the demand and my lord.
Okay, heard Mr. P. Kotoke, the learned senior counsel, assisted by so-and-so, for the petitioner. Also heard Mr. B. Sharma, the learned APP for the state. Learned APP prays for some time to go to, learned APP submits the CD has been received, but CD has been received. However, he could not go through the CD. And therefore prays for some time. Did the matter be listed? When?
Next week, my lord. My lord.
5th of July, 5th July.
August.
Oh, sorry, August, 5th August.
Well.
No steps have been taken in this matter. This is a state.
Yes, sir.
But you have not taken the steps.
So we'll take steps for it.
Okay, office note dated 22/7/2026 reveals that no steps have been taken for issuance of notice by the appellant. Mr. D.P. Goswami, the learned APP submits that he should be allowed some time to take the steps accordingly. For 4 days time from today have been given to the appellant to take steps in the instant case for service of notice. Let the matter be listed after 2 weeks. For 2 weeks. Some report was supposed to be produced.
Not receive any report. Case was search secret, lordship. Regarding Zimma of a vehicle, lordship.
That report of the IO, no?
Yes, sir.
Report of IO is required.
Only the report upon completion of the investigation, the case was search sheeted by search sheet number 9/26. The case diary along with the search sheet, all concerned papers was provided to the Honorable Court of the Magistrate Hailakandi on 19/3/26. It is submitted the seized vehicle is presently kept in the premises Algarve police station.
No, the thing is the report was
Yes,
sub
yes.
for report is
That report
required.
is, we have not received yet.
But you have taken so much of his vehicle will be
Yes.
damaged.
It's another date, we will try to produce the report. Lordship.
Already sufficient time has been granted.
Your Lordship, if further time is granted, then my application will be infructuous. Because I need the vehicle for the monsoon season. I need the vehicle for the monsoon season due to the. For the monsoon season, Your Lordship. I have an ailing mother So I need the vehicle. That is the only mode of
Okay,
transport.
we will fix it on 4th August. And if in the meantime, if, I mean, the report is not produced, then a court will pass order to release the vehicle.
Your Lordship, previously also, in the last date also, Your Lordship, it was stated that today it will be disposed. Your Lordship may rely.
No, the last order, it was nothing like that was. Last day, nothing like that was ordered.
That's why that's why it was fixed for.
So that is why we are fixing it on 4th. If now the report is not produced, then we'll release our vehicle. Heard Mr. S. Talukdar, the learned counsel. Learned counsel appearing for the petitioner. Also have the DP Goswami, learned AP for the state. For the state. On 17/7/2026, the learned AP for the state submitted, as I have prayed for some time to submit the investigating officer's report. However, the same is yet to be submitted before this court. Taking into account the fact that the vehicle was seized when?
On November, Your Lordship.
Vehicle was seized in the month of November and lying in the police station.
26 November to be precise.
26 November so and so. Lying in the police station. This court is of the opinion that on the next date fixed, that is on 4/8/2026, the court shall pass the appropriate order, irrespective order, without the report of the police, report of the investigating officer. Let the matter be listened for 4/8.
License.
20.
Well, the same matter, in the morning, Your Lordship.
Oh, that matter, okay,
Yes,
okay. So you want to file the objection?
Objection, madam.
Objection to this. Who is appearing for the?
Who is on the VC, madam?
I'm appearing for the petitioners in this matter.
You are not audible.
I'm audible
You
now.
are not audible. Mr. Miglani, you are not audible. The connection is lost again. Okay, heard Mr. Mohit Miglani, the learned counsel, who is present for video conferencing for the petitioner.
I'm audible now.
Come on, the learned senior counsel and learned special public prosecutor for the state, assisted by Mr. P. Datta. Mr. Miglani, he is seeking for some time to file an objection in the matter. So we are granting him some time. Okay. You are not audible as yet.
I'm audible now.
Filed by Sesoria, item number 30. 6 to this item. This is
Mr. Bora appeared.
Yes.
So
Because
that was
here
fixed on?
the petitioner is one Sesoria, my lord. Chetan Dhirasaria, my lord.
Okay, so we'll fix it on the same date.
Same date.
On which date was the? 11.
On
11, okay.
11.
Mr. Ajit Kamal, the learned special public prosecutor, Mr. Ajit Kamal, prays for some time to file objection in the instant case. His prayer is allowed. Let the matter be listed on 11/8/2026 to 11/8/2026 along with
787 criminal petition.
787 criminal petition number 787 of 2026.
Am I audible now?
You are not audible. So same date.
Yes, ma'am. Also regarding item 21 arising out of the
Same
case. No, different ballot. This is for freezing of the bank account. This is for against that Mahavir Ekwa.
I mean, Now, this is also Mr. Miglani, you are appearing in this matter also.
Yes, my lords, I'm
So here
appearing.
also you'll file a objection.
Absolutely.
The same order will go. Same order
My
will
lord.
go. And list this matter also along with other two matters.
Yes.
My lords,
Well,
my lords.
actually, it is no way connected.
Oh, no
but
way connected.
separately.
Okay, then you need some other
Being
date.
late, my lord, but
Then list it on that, not with the other matters, okay? List it on so and so objection.
My lords, I'm grateful, my lords. Lords, my appearance may be marked, my lords. Thank you.
Okay. Premier petition against the order dated 26/5/2026 for the petition file a general petition.
My lord, may I intervene, lordship? I'm for the response number 2.
Scan copy has
Lordship.
come. No.
Scan copy has not been received, lordship.
TCR is yet to be received. Let the matter be listed.
And
On
it's for that matter since 2005.
2012.
No, sorry.
No, lordship.
3/5/2026. The cattle is under the custody of the.
3/5/2026.
Lordship.
The month of May.
Cattle.
Cattle.
You want a Zima of cattle?
Yeah, of cattle.
Okay,
For that
okay,
time.
but
I'm
TCR
for the
hasn't come,
response number
so
2.
we'll fix it on 7th July or 7th August. Or 7th August is
And prior 4.
6th August.
6 I not available. Lordship.
Hmm?
Have some difficulty, Lordship.
Then 7th August. 7th August.
The scan copy.
My appearance may be marked, lordship.
For register.
That
They are not registered, I think, that's why not.
no, the order is already there.
My appearance may be marked, lordship, for response number 2. Lordship. My lord, my appearance may be marked for response number 2 in item 22.
Lordship, I'm here for the respondent number 1, but my senior counsel has to suddenly travel out of station because of some medical issues. We have submitted the medical note to the court. And request.
Okay, we'll give some time. Okay. Your name?
S. Rasbongsi.
Huh?
S. Rasbongsi.
Heard MS H. Rasbongsi. S. Rasbongsi, the learned counsel for the applicant.
Petition.
Would have for the petitioner. Also heard MS
K. Das.
K. Das, the learned counsel for respondent number 1. MS K. Das submits that the senior counsel. Who is the senior counsel?
Dr. Junmoni Devi Khan. Dr. Junmoni Devi Khan.
Where is she?
She's in Hyderabad at the moment.
But we can see a lot of video footages.
Yes, Yana, she has only traveled on the 21st. 21st, she has traveled to Hyderabad.
Okay. Submits that that the conducting counsel in the case is out of station due to medical reasons. Therefore praise for adjournment of the matter. Let the matter be listed. When she is coming back?
6th August. 6th,
Huh?
6th August.
Let the matter be listed on not 6th August. I'll fix it sometime in. Okay, 6th August.
Organization. Lordship, as per office note dated 22/7, notice upon respondent 2 has been awaited, Lordship.
Office note dated?
22/7/2026, Lordship.
22/7. Okay. Service report is awaited. Let the matter be listed.
Lordship, there is an interim order.
Let the matter be listed after 2 weeks. Interim order so passed earlier shall continue till the next date of listing. But TCR will be required in this case probably. It has been sent back. We'll see. TCR not received.
48 Lordship TCR received Lordship,
Hmm?
but it is pending for filing objection on our behalf Lordship.
Written opposition filed on
Whether it is filed Lordship?
no written objection filed on behalf of state has not been received till
Yes,
raised till
not
date.
yet come forward, because in the
I
last
don't know why they are
occasion-
writing filed and not received.
Last occasion, my learned friend MP Goswami appeared Lordship. So I will have to take instruction whether he has filed or not.
Lordship, a date may be fixed.
Heard MS so learned counsel for the applicant. Also heard Mr. MS SH Bora, learned PP for the state. Learned PP for the state submits that written objection in the matter, submits that C needs to verify whether a written objection in the instant case has already been filed or not. Therefore, prays for some time, let the matter be listed after 2 weeks.
Lordship, on 11th of August.
After 15 August Lordship.
Okay, let it be fixed on 16th of August.
Lord,
16th of
kindly
August.
obliged.
16th of August.
Obliged, Lordship.
Oh, 16th Sunday.
17 Lordship.
18th of August. 18 August. Huh?
Lordship.
May I please your lordship? My lord, in this case, service is completed, my lord. And my lord, scan copy of trial court is required, that may kindly be
It was not called for earlier.
not called for.
Parties are duly represented. Service is complete. How are you saying? Where is that record?
My lord, 18/9/2025, my lord.
18/9/2025.
Yes. There is a report from Zarikar of mine. On that basis, it is complete.
Okay. Service is complete in the instant case. Instant case registered to call for the TCR.
Scan copy.
Scan copy of the TCR in connection with which in connection with
PRC 802 of 2022.
from which court?
CGM Nalbari, my lord.
From the court of the learned CGM Nalbari. Let the matter be listed after 3 weeks.
4 weeks, my lord.
Okay, 4 weeks, after 4 weeks.
That is an interim order.
Interim order so passed earlier shall continue till the next date of list.
May I please, your lordship? Lordship, we have taken steps on lordship 9/6/2026.
Hmm?
We have taken steps relating to the COPSOL, who was convicted
Yes.
of 10 years.
Service is complete over.
In the official lordship, there is no
Hmm?
reports, no report regarding service lordship, but TCR arrived.
People's status, no?
9/6/26. Steps taken.
Then you verify. You verify from the registry. Because there is no report here. Okay, heard Mr. Ayush Chaudhary, learned counsel for the appellant, also heard SS Bora and APA for the state.
Lordship, service through office of the.
Those steps for service of notice on respondent number 2 has already been taken. No report of service of notice could be found in the records. Registry to verify the same. and put up a report regarding that, regarding the service of notice to respondent number 2. Let the matter be listed after 3 weeks.
Obliged.
This is again your matter.
Yes, Lordship, this is appeal against equity, Lordship. We have reports may be called for, Lordship. It was earlier probably called for.
TCR is not received, TCR is called for.
Yes.
TCR not received.
This is very minor.
TCR is received or?
Not received.
TCR, MSSH Bora, the learned APP is present for the appellant. TCR not received, let the matter be listed after 3 weeks.
Obliged, Lordship.